Applications and extension of Indian order, please hand over first.
May I seek my lords?
The others will hear. Yes. Application and extension first hand over.
Application matter will fixed to petitioner will evict.
Please hand over.
Fixed yesterday matter will.
How can you fix it yesterday? Application now, just side it. Yes, the other matters. Mr. Boss, yes.
Yes, may I seek my lord's kind indulgence?
Yes,
Leave. Have a number because the matter can be released today, my lord, supplementary list because Mr. Shukanta Chakravarti appeared in the
Yes.
I need the supplementary list for this. I'm supplying the number to your lordship. So urgency is this, devolution order has been passed.
When we'll publish a supplementary list.
Number.
Just ask a junior to give the number.
Yes,
and if possible, inform the other side also.
Yes.
Wherever you take it, I mean. Yes.
My lord, may I be permitted to mention one appeal hearing matter of the
Which year?
2021, my lord.
Yes.
Very short part involved in the matter.
During the year 2024.
Wait for some. Start taking, occasionally you are taking, yes.
Your Lordship, it's an appeal from an injunction order passed by the learned civil judge from this year. 2026, Your Lordship. My ingress and ingress from even from the common water pump has been padlocked, Your Lordship. It's an undivided property.
Hand over. You have been coming for quite some time, yes.
Thankfully, grateful, Your Lordship.
Yes. Appeal. Yes.
I permit to mention one WPLRT read, my lord.
Wait for some time. We have so many WPLRTs.
Two matter, my
when we reach up, no, not right now. Yes.
One hearing matter, in 2025, my release has been released. Release has been refused to renew. But 500 families are at stake. Because of the closure of this business.
Please wait for some time. Yes.
May I come back in the next week? Subject to correction.
Don't think you will be able to. Next week, don't think. Yes.
Order 41, Rule 11.
Yes. Yes.
Your Lordship, this is for inclusion in the list. This is a first appeal. And
which year, ma'am? Which year?
First appeal is filed in this year.
Which? Oh, this year?
Yes.
First appeal is not required to be admitted.
Okay.
Application is there?
Yes, Your Lordship.
Write application and handover.
Or inclusion. The urgency is that...
We'll take it. Write application and handover. And thank Mr. Sinha. Yes.
For inclusion, order 41 Rule 11. Grateful.
Yes.
The inclusion in the hearing that the paper book has already been submitted.
Wait for some time.
Yes, sir, ready for.
No. Yes.
My lord, it is to be mentioned. First appeal of 2025. Your lordship.
25 first steps we are not taking for hearing, ma'am. If there is an application, you can mention it on another day. Yes.
Lordship, order 41, Rule 11 appeal. Much obliged.
For the application, Your Lordship, the urgency is that.
Whenever the file comes, it will be listed.
Order 41, Rule 11.
Yes. Call on the list.
Order 41, Rule 11.
No further. Yes.
But this was for filing the written notes. Yes. Okay. This for filing the written notes, Lord. As not taking a day's extension.
Tomorrow we'll keep it.
Kindly.
Oh. Tomorrow it was due to come.
But in the order, it has got down to today's date.
Oh.
Actually, I
asked for extra days time.
So would you like to file today? Written notes of arguments filed on behalf of the appellant today be kept on record. Full Let the matter be listed under the same heading tomorrow. Mr. Rai and Mr. Kaur.
Yes.
But he is leading me, my lord. It is my fault, my lord. I took some time.
No. Tomorrow, for the purpose of filing of written notes of arguments by the respondents.
This actually goes to the other bench, Lord. The matter was heard by your lordship sitting in that other determination.
Then, my lord.
Really doesn't matter, Lord.
No, but how can you close hearing, man?
No.
It was already concluded. Your is recorded.
Only for the purpose of...
Hearing is concluded.
Very well, we'll put something in our order. Some innovation.
Much obliged.
Had bench will pass this judgment.
Yes. I thought I'll just remind your lordship that.
No, thank you
very much. Has to go to the other. Yes. Much
Grateful.
Your Lordship, because this is that matter where Your Lordship wanted me to come back with some names, Lord, for appoint of the auditor.
Yes,
Lord, the ashram matter, Lord.
Yes.
The trust, Lord, where it was an issue. Lord, unfortunately, Lord, the names are there, Lord. Yes, yet it has not come to me.
We'll keep it tomorrow or day after tomorrow.
Keeps it tomorrow.
On the prayer of learned counsel for the respondents, the matter is adjourned till August 12, 2026, when it will be listed under the same heading. Next. Yes, written notes.
No, this is because your lordship wanted to send this
Mediation.
to mediation.
But
I have
this is,
spoken to my client, subject to what Mr. Kaur says.
Yes.
Anybody with an engineering background, because this will need
But,
somebody.
the dispute was that they are alleging that due to the construction that my clients
Yes,
are
yes,
making
yes.
to an adjacent plot, certain damages have taken place. They have filed an application under Order 26, Rule 9, but my lord felt that the matter can go to mediation. Lord, I was thinking, Lord, this is a suggestion that, Lord, kindly appoint an advocate with instructions, Lord, to, with a direction to, Lord, take help either from the engineering department of the Jadavpur University or, Lord, IIT.
That can also be done.
For the purpose of ascertaining, Lord, whether it is according to our fault. Because, Lord, our instruction is that the adjacent building is also equally, Lord, old. So, this will be a process of engineers for the purpose of, Lord, finding out whether actually.
That can also be. I don't
Whatever you
mind
say.
that. Any advocate may not, but the
We were
engineering part
thinking
has
about
to be
mediation,
obviously
because
done by.
mediation, the mediators are also entitled to do that.
I see.
Mediation committee also has this panel and all this engineer.
Mediation.
Because this is a matter where may not be adjudicated, and the advocates can also appear there before the meeting.
Yes, of course.
You know that. Yes.
No, but I misunderstood. We can go before the.
Yes, we'll just say that it will be open to the mediators to appoint appropriate persons with engineering background or take the help of, you say IIT Kharagpur.
Yes, Lord.
Jadavpur
Either
University.
Kharagpur or, Lord, the Jadavpur.
Hey, your lordship will kindly appoint somebody from the panel of the.
Our experience is not very good.
No. Mediator. Mediator from the panel.
Lord,
It will require a little bit of a practical approach.
and I'm told by Mr. Chatterjee that in a similar situation, Mr. Kollul Bose was appointed, and, Lord, he was appointed as a special officer and with a direction to take help of the.
Sir, Kollul Bose is too busy, Mr. He's too busy. That's the difficulty.
Then
you can appoint if you want.
No, I leave it to.
But then it will be two rungs. Then again,
two runs.
Advocate and advocate appoints.
Or your lordship can directly, Lord.
We can keep it. I mean, we'll say that the mediators will take the help of engineers from the. If you choose IIT Kharagpur or Jadavpur, we can put it in
either.
For that purpose, it can be done. You can also put in your engineers reports or whatever. Senior counsel appearing for the respondents submits on instruction that a person with engineering background may be appointed in order to resolve the dispute between the parties. First up, it is suggested that an advocate or a mediator may be appointed who can take the assistance of engineers from the Indian Institute of Technology, Kharagpur or the Jadavpur University for the purpose of for such purpose. First up, next para. Upon hearing learned counsel, it transpires that the matter that in principle, the parties do not the parties agreed to the matter being settled between them amicably. Full sub next para. Accordingly, the matter be sent to the mediation committee, Calcutta High Court mediation committee for the purpose of settlement by mediation. Full sub next para. It is made clear that it will be open to the mediators to appoint engineers either from the IIT Kharagpur or the Jadavpur University, if necessary, for the purpose of arriving at such settlement between the parties. First up, liberty to the parties to mention the matter for inclusion in the list in the event mediation fails.
Obliged.
এটা পাঠিয়ে দেবেন আজকে।
But I appear for the respondent, Milord. My lord,
I am appealing for the appellant.
Milord, before my learned friend said, my lord, will recall, Milord, on the last occasion, Mr. Thakkar has said, Milord, my client is willing to, Milord, concede to the prayer of the appellant, Milord.
Yes.
And, Milord, your lordship directed to bring, Milord, the written instruction, Milord, the written instruction, Milord.
Just give us the background once. Background.
Milord,
Because if you, we have to record something, we have to set aside.
Only thing is this, that according to us, it's a misconceived suit. Suit for defamation. Suit for defamation doesn't lie. It is between two, my lord, litigating parties, and my lord, the correspondence which were exchanged between the parties, that is the basis on which, my lord, this suit has been filed for defamation. Principle of qualified privilege, principle of fair comment, principle of justification. I mean, there are so many things by way of defense that can be taken in this suit.
What has been challenged in the appeal, Mr. Mitra?
My lord, this
What order has been passed?
ad interim order without notice to us. My lord, we have been restrained from, my lord, writing letters. My lord, to the authorities, my lord, saying that, my lord, this is I have not come across this kind of a suit, my lord. My lord, I am going to make an application, move an application in the trial court for under Order 7, Rule 11 for dismissal of the suit.
Milord,
That
in
is
fact,
my
they have
instruction.
filed their Milord written objection to Milord the injunction application. That is why Milord, it was Milord submitted by Mr. Thakkar that without expressing any opinion, Milord, if it I am consenting to that setting aside without Milord, and then can be agitated all the issues before the trial court. Milord. It was an ex parte
The
or
difficulty is if it was the appellant conceding, I mean, not proceeding with the appeal, we need not record any reason. But if the respondent concedes, if the court, we have to set aside that order.
Yes,
That
sir.
cannot be done by mere consent. We have to write a line or two regarding reasons also.
Milord, if
That's a difficulty.
My lord, I
Or we
wonder-
can make it a consent order sort of thing, without even going into the merits. If you
Yes,
touch the
your
merits,
lordship, my lord, record our consent also. We do not object to their so, my lord,
very well be.
by consent, your lordship can sit.
Notes নিয়ে করে দিচ্ছি।
Your lordship can have it recorded that everything.
That's why we asked him.
Yes,
Yes.
and my lord, on the basis of that, my lord, your lordship, on the basis of consent,
Yes,
your
yes,
lordship can
yes.
have it said.
At the time of call, comma, Mr. Thakkar's name, you will give Mr. Thakkar's name.
yes, Milord.
So you'll have to say senior advocate then. So you put in the name later on and we say advocate.
No, Milord, I am
So indicate to us, yes. So the learned senior counsel appearing for the respondents hands over a written instruction given by the respondents indicating that the respondents concede to the prayer made by the appellant in the present appeal for sub next comma without prejudice to the rights and contentions of the parties in the main injunction application pending in the trial court. For sub next para, learned senior counsel appearing for the appellants agrees to such proposition. For sub, although learned senior counsel for the appellants also seeks to point out that the defendants stroke appellants will uh, make a demurrer application, may make a demurrer application in the trial court challenging the maintainability of the suit, comma, be that as it may, comma, in the event we enter into the merits of the matter at this stage, comma, the same may unnecessarily prejudice the learned trial judge at subsequent stages. For sub next para, since the parties are ad idem on the appeal being disposed of by setting aside the impugned order, comma, FMA 885 of 2026 is allowed on consent, comma, thereby setting aside the impugned order dated April 18, 2026, passed by the learned civil judge, senior division, first court at Alipur, district South 24 Parganas, in title suit number 170 of 2026, and requesting the learned trial judge to dispose of the main injunction application as expeditiously as possible, comma, you have filed your written objection.
Yes.
Preferably within 6 weeks from the date of communication of this order to the learned trial judge. For the next para, we make it clear that the merits of the matter merits of the matter have not been gone into, and it will be open to the learned trial judge to dispose of the injunction application and stroke or any other application, comma, if filed by the parties
Okay.
on their own merits and in accordance with law without being influenced in any manner by any of the observations made here. Very good. Can such and such is also disposed of accordingly. We have put in this rider because otherwise it may be construed that we have directed the injunction application to be heard out, therefore your 711 won't be taken up. Sometimes it happens. So we have said or any other application. No. Thank you. Next.
This is suspension of sentence.
Oh, our determination has been taken. Now it's just.
My lord, I beg to appeal for appellate number 1 to
Determination has been now given to Justice Arindam Mukherjee's bench. When you mentioned we had determination, but now we don't have it. It has been recorded.
My lord, till today, your lordships had a determination, my
Had.
lord.
Revoked by specific order. Since this bench does not have determination to take up these matters, let the matter go out of the list with liberty to the parties to mention the same for inclusion in the list of the appropriate bench. You can mention it during the course of the day. We'll ensure that the file goes quickly and we'll sign this order as early as possible.
Great.
May it please your lordship.
One thing. Yes. A single thing. Yes, Mr. Dutt.
Prior to placing the impugned order, my lord,
Yes.
I intend to place few documents. My lord, on 10th of April 2023, concerned BLRO issued a notification.
Mr. Dutt, we started hearing it.
My lord?
We started hearing it in the other bench. We started hearing this appearing for the first time.
No, the interim order has been given by your lordship, my lord.
Achha, just remind us the facts of the case once because this is a new bench. Yes.
My lord, on 8th of March 2023, in a nutshell, just I am giving.
Yes, nutshell.
On my lord, on 8th of March 2023, the writ petitioner filed an application for conversion of the classification of the land. So, my lord, on the basis of this application, and in whether an inquiry was conducted or not, we don't know. The concerned BLRO issued a notification saying that you restored the water body, that means classification is DOBA, and you by demolishing your existing structure. Then that notification was kept pending for their consideration. One claiming as a public spirited citizen approached before the Honorable High Court by filing a public interest litigation.
Already the demolition order was there against you.
Yes. And praying for a implementation of that demolition order. So, my lord, although, my lord, the writ petitioner entered appearance, but the learned counsel, he did not place all the facts before the court. Subsequently, an order has been passed, simply directing the authority that you come to a conclusion by taking steps on the basis of your notification, which has already been published. When, my lord, subsequently, he has been, by having been advised, the, my lord, the writ petitioner before your lordship, my lord, he filed a review application of the order which has been passed by the Honorable Division Bench in a public interest litigation. In the review application did not succeed, but there is an observation that, my lord, the point which has been taken, it cannot be said that these are the ground for reviewing an order, but the fact remains liberty would be given to you so that you can file a comprehensive representation to the concerned ADM and LRO before whom the matter is pending for consideration. On the basis of which a comprehensive representation has been filed along with all those documents in support thereof. While considering this application, my lord, the ADM and LRO passed an order saying that this is not a case under section 4(1)(c), but it would be, my lord, a case under rule 166 of the West Bengal Land Reforms Manual. What it says, my lord, normally 4(1)(c), it is for the conversion. And, my lord, the 166 is a provision, and that is, my lord, pertaining to the post facto conversion, when, my lord, certain eventualities would be there, that the land has already, by dint of the, my lord, the natural wear and tear, or by the development, the character of the nature of land has already been changed, and subsequently, the, my lord, the person concerned is residing over there or using the said land for any other purpose. Yes. In that event, Rule 166 can be imposed, and subsequently an inquiry can be conducted. Then, my lord, the initial proceeding has been dropped by dint of the order passed by the ADM and LRO, and, my lord, a proceeding has been, separate proceeding has been drawn up under Rule 166 of the West Bengal Land Reforms Manual of 1991. Subsequently, when, my lord, he has taken up this application, we filed to one document, that is the property tax receipt issued by the Frezarganj Gram Panchayat. After seeing this document, it has been observed by the ADM LRO and directed the departmental authority to ascertain the veracity of this document, whether that document is authentic or not, and directing the concerned Pradhan of the Gram Panchayat to verify the authenticity of the said document. After receiving the said thing, my lord, the concerned Panchayat verified the said document and saying that this is an authentic document. And a report has been given to the ADM LR. After seeing this, my lord, the ADM LR hold that, my lord, this is not the sufficient document, although the authenticity of the document has been affirmed, but since other document has not been given, and it is the and my lord, the and impression has been given that it is the obligation on the part of the writ petitioner or the applicant therein to prove his case by producing a document that the land has already been converted prior to 24th of March 1986, which is a precondition engrafted under, my lord, Rule 166. Then, challenging the propriety of the order, an original application has been filed before the Honorable learned LRTT. And learned tribunal, my lord, while taking up, there was a prayer for the interim order. That interim order did not consider, because this is the procedure your lordship can take judicial notice. Normally, the date is fixed after 6 months or 7 months thereafter after filing. In the meantime, my lord, the concerned BLLRO, on the basis of the order passed by the, my lord, the ADM and LR, passed an order directing demolition of the existing structure and for the restoration of the water body once again. For the implementation of the order.
What was the last order of the ADM LLO?
26th of, my lord, 26th of December 2023.
What was that? Your representation was considered.
My representation was considered, invoking 166, but it fails. It dismissed.
So BLRO now implements that.
BLRO now implement the original order. Then, my lord, challenging that, we have filed an MA application or interlocutory application before the learned tribunal. Learned tribunal did not consider.
MA was in connection with what way?
Way 61 of 90, challenging the order date 2024.
Of the ADM LRO?
Yes, challenging the order dated 26th of December 2023 of the ADM LRO.
That was the principal order.
That was the principal order under challenge in the way application.
Implementation you challenge in MA?
MA. The, my lord, I did not get any order, interim order or interim protection in the MA. MA was dismissed, got dismissed. Challenging the propriety that order, my lord, we have filed a WP LRT before this honorable court. Honorable court, my lord, has passed an order affirming the order passed by the learned tribunal. Challenging that order, my lord, we have filed a special leave petition, and ultimately in the special leave petition succeed. And, my lord, there was an interim order in the form of a status quo that the demolition would not be carried out till such time way application would not be disposed of. And direction was given to preferably to take up the matter within 6 months. Then this matter has been, when this matter has been taken up for consideration, that public spirited citizen filed an application, interlocutory application before the learned tribunal, saying that I intend to implicate a party respondent. Their application has been allowed. Challenging that order, my lord, we have approached once again before this honorable court, and this honorable court, my lord, presided by your lordship, my lord, passed an order rejecting the order passed by the learned tribunal, saying that the public spirited citizen cannot espouse his own cause subsequently and cannot be implicated as a party respondent. And certain observations was there where it has been categorically mentioned that if the, my lord, the state or the, my lord, the applicant intend to produce new document in support of their case, they can disclose it. Subsequently, thereafter, when the hearing was going on, my lord, by strength of your lordship's order, and subsequently, my lord, the considering their observation, a liberty has been granted to the, my lord, the applicant to file a new document. So, a supplementary affidavit has been filed in connected with the way application. What it says?
Document?
Document is, my lord, one format of the 166. That is, if the inquiry is conducted, there is a specified prescribed format.
What have you challenged here?
My challenge is, my lord, the order dated 26th of December 2023 passed by the ADM and LRO, my lord, which has been affirmed by the order passed by the, my lord, 15th of July 2026 passed by the, my lord.
So that way has been dismissed now?
Way has been dismissed.
What is your main ground?
My ground is this, my lord.
Your conversion, the report was there prior to 24th of March 1986. You had
my lord
constructed.
My lord.
That is the primary ground.
No, my lord. My simple reasoning is this. law says, Milo, kindly have a look at first 166 once. Where the conversion has been made before making application for permission, while disposing of the petition for the conversion, it may come to the notice of the collector that the land has already been converted to some other use other than appearing from the record of rights. That means, my nature of was Doba, but that is using as a hotel cum residential premises. Such a case should be normally be dealt with under section 44. In such cases, it should be inquired as to whether the change in the use has been made in usual course of the nature or by deliberate action on the part of the applicant or any other person. And in the latter case, it should also be ascertained whether the charge took place before 24th of March 1986, that is the date of the publication in the official gazette of the West Bengal Land Reforms Amendment Act of 1981. Kindly pause for a moment, my lord. 166, my lord, it is not a normal provision. It is a provision where post facto permission would be given, considering the ground reality which will be, my lord, emanated from an inquiry report. And this inquiry report is a condition precedent which is required to be conducted by an authority.
Here there was no inquiry.
No inquiry.
Burden was shifted on you to say that you could not prove.
Yes,
No.
that has been mentioned in the original order. So next, kindly take the next one.
Roman 2, A, B, C, D, these have not been considered.
Not been considered.
According
Because unless the inquiry would not be conducted,
Report,
the fact finding.
unless the report comes this way.
Yes, yes.
According to you, under which one do you come, Mr. Doctor?
The ordinary course of business, my lord.
No, that's in the usual course of nature.
The usual course of nature, my lord.
Not nature. Nature cannot make it takes millions of years for evolution. It cannot make a hotel. Usual.
No. We have been staying over there since prior to 1980.
Usual course of nature is not the nature of the property. Nature means, I mean.
My lord, let me come, my lord. Has occurred in next B, my lord. 2B has occurred at a time when the such change was not unlawful.
So, Doctor, give us half a second. Please come to one once.
One.
In such cases, now, while disposing of a petition, it may be come to the notice that it has been constructed, converted to some other use.
Yes.
Such a case should normally be dealt with under 44. In such cases, this is one. It should be inquired as to whether the change in use has been made in the usual course of nature or by deliberate action on the part of the applicant. Whether the change occurred by nature, wear and tear, or whatever, change by nature, and as opposed to deliberately, you have built a proper structure. You have built a structure.
My lord.
It has to come either within this C or D.
Then, my lord, kindly have a look at
activity
2
or urbanization.
Then 2, my lord. Then 2.
Then 2.
If the change in the use has occurred in a usual course of the nature or has occurred at a time when the such change was not unlawful, that means prior to 24th of March 1986.
So it was at that point of time you say it was not unlawful.
My lord, has occurred due to the development activities.
Not of the government. This is not of the government.
No, this is development activities of the government or the local body in the surrounding area, or due to the urbanization of the surrounding areas, and the applicant and the should be informed.
But
in
you say these have to be gone into.
My lord.
Before a report, it will be premature to say any of these.
My lord. So apart from this, what is also coming, my lord, straightway kindly have a look at, my lord, one document that is page 104. This is very alarming. Kindly see the supplementary affidavit. Prior to that, my lord,
supplementary.
My lord, kindly take your lordship's order once, my lord.
Supplementary affidavit kothay?
This is the paragraph 43.
Supplementary affidavit?
No.
Annexed to the writ petition.
Annexed to the writ petition.
Page 104.
104. Prior to that, my lord, kindly see your lordship's order. Then it would be, my lord. Ami dada eta diye dichhi. Paragraph 43. It is expected, my lord, got it?
Got it.
It is expected that the learned tribunal shall proceed as expeditiously as possible in terms of the order of the Honorable Supreme Court to decide the original application pending before the tribunal without being prejudiced on merit by any of the observation made above. It is further clarified that it will be open to both the parties and the state to place all relevant documents if not already placed including the order passed in the public interest litigation before the tribunal to facilitate a proper comprehensive disposal of the original application. Then, my lord, kindly have a look at 104. This is the supplementary affidavit. Paragraph 5 onwards at page 6. Having heard the submission advance on behalf of the applicant by an order dated April 8, 2026, liberty was granted to the applicant to file supplementary affidavit for bringing some document which were subsequently found out by the applicant on record. During thorough searching, the applicant found out a printed prescribed format of an inquiry report in the light of the Rule 166 of the West Bengal Land Reforms Manual of 1991 and a report submitted by Sri Ramesh Maji, Revenue Inspector, as an inquiry officer. The said document is a photograph of the report taken by the applicant number 1 herein himself from his mobile phone. For maintaining the such record, the applicant number 1 has downloaded the said photograph from his mobile phone through his laptop and took a printout of that photograph. Applicant number 1 has personally checked and verified the photograph of the report which was taken by the mechanical means in the same and identical photograph. The content of the photograph is true and correct. Kindly have a look at me, Lord, page 109. As per Rule 166, my lord, when an inquiry is required to be conducted, this, my lord, format is normally being given to the inquiry officer. This is the prescribed format. Kindly see, my lord, next document. One Ramesh Maji was appointed. He has taken a photograph on the relevant point of time. Kindly see first page, nature of case, because this is illegible. That's why this, my lord, prescribed format has been given. Nature of case, Sreni Porivartan. Case number has been mentioned. Then name of
Which
the, my lord,
page? This is
110.
110.
yes.
My lord, your lordship has to see, my lord, along with 109. Otherwise, my lord, the what is requirement, then most
Left hand
of
column
this-
is not there in this.
yes,
Left hand column is not.
yes, that is not legible.
You have
That's
to
why I am-
convert from the previous. Great.
yes. Kindly see, my lord, 1681. The number is this, which is very pertinent. Change of the classification of the land not due to in course of the nature occurred before 24th of March 1986. Yes. Then, my lord, kindly have a look at next. Occurred due to the departmental activities of the government of the local body surrounding such and such. Then no in 3 cases. Then the remark. Very, my lord, in Bengali vernacular. জমিটির উপর আবেদনকারীর আবাসিক হোটেল নির্মাণ করিয়াছে যাহারা নিজে পরিবার সহ বসবাস করেন। তাই কি পড়তে পারছি না, বসবাস করেন। তারপরে ঠিকই শুরু হোটেলটি এত সালে শুরু হইয়াছে বলিয়া জানা গিয়াছে।
এত সাল is 2010 or something.
2010 or something else.
That's much after 1986.
হ্যাঁ। বয়স্ক মানুষজন হইতে আরো জানা যায় যে আবেদনকারীর পিতা নির্মল কুমার সর্দার প্রায় 40 থেকে 45 বছর পূর্বে মাটির ছাউনি খড়ের ছাউনি দরজার দরমার করিয়া বসবাস করিতেছেন। একটা মানে গ্যাপ। এই অবস্থায় বিদ্যুতের কোনো ব্যবস্থা ছিল না।
শুধু একমাত্র 86 এর আগে এটা হতে হবে। এই দ্বিতীয়টা হ্যাঁ আছে, মানে অকার্ড বিফোর এটাতেও হ্যাঁ আছে। ওয়ানটা হ্যাঁ করে দিল। হ্যাঁ দেখ, ইন দ্য কোর্স অফ নেচার আর কোর্স অফ নেচার হ্যাঁ বলেছে। আর দ্বিতীয়টা হচ্ছে তোর 86 এর আগে। 86 এর আগে হলে বাকিগুলো তো বাকি যেগুলো বলছি।
My lord, this document surprisingly has not been disclosed. When the
document has no value.
My lord, no doubt, my lord, this document doesn't have a
have a new report.
Yes,
that you can say.
Good, bad, indifferent, my lord, the order impugned before your lordship, my lord, did not, my lord, employ single word. So far as the supplementary affidavit is concerned, that is doesn't have any evidentiary value. It has come, it cannot be relied upon. This language, this particular, my lord,
What is perverse in any event? If it says a hotel has been built in usual course of nature,
So whatever might be, my lord, this is the one aspect of the matter. Next, my lord, the next document, once again, kindly see. This is a property tax receipt. Initially, we have filed one property tax receipt. This is a property tax receipt in the name of my father, Nirmal Kumar Sardar. Date is 15th of March 1982. My lord, bottom left-hand side, Tariq.
Yes.
This is a, my lord, they are residing and giving panchayat tax.
1982.
82. And prior to that, my lord, 1981 document has been given. Page 37, my lord. This is also a property tax receipt.
Page
37. Which has been, my lord, submitted along with the comprehensive representation, which has been considered and veracity of the document has been proved. 24th of March 1980. কোথায় আমরা পাঠিয়েছিলাম তারপরটা পাঠিয়েছিলাম এটা যে ভেরিফাই করতে পারি kindly have a look at page 79 87 on being inquired.
These were not the rest of the documents, 37, 87. These were not annexed to the supplementary affidavit.
No. This is the original document, my lord,
The
which
new
have been...
documents you are producing before this appellate court for the first time.
Supplement.
Can you look into this?
No. This is the original document has been filed before in the way, and that was there before the in the, my lord, comprehensive representation before the ADMLR.
Part of all those.
Yes. And this report, my lord, given, and that has been given pursuant to the direction given by the ADMLRO to the DA, departmental authority, to ascertain the veracity of the document dated 24th of March 1980. So, my lord, concerned Panchayat, my lord, kindly see, the language would not be, my lord, correct. Veracity of the document being number such and such issued by the Frejanganj Gram Panchayat. First of all, congratulations on behalf such and such. A letter sent by the VD memo number such and such dated 15th of December 2023. This is issued by the ADM LR office. In compliance with the instruction of the letter, I assure you that the late Nirmal Kumar Sardar father such and such personally knew the said person. It is true that he paid the tax VD receipt number such and such for the collection of the Panchayat taxes, duties and fees dated such and such as per Gram Panchayat rules. And it is also proved that the Honorable Pradhan, on behalf of the Frejanganj Gram Panchayat dated 10th of November 1998, recommended for the settlement and
The
particular...
Pradhan himself writes, glorifies himself with honorable. What is the congratulation for?
I don't know, my lord.
Yes. So Honorable Pradhan, what has he done? He is himself writing Honorable Pradhan.
My lord, since somebody has...
Minor. Yes.
Then kindly have a look at the original order which is impugned before the Honorable Tribunal, a learned tribunal.
Do you say these documents were not considered at all?
No.
We are not a fact-finding forum.
No, not at all. Not at all considered. Even apart from this, if I don't have any document, it is sine qua non that, my lord, an inquiry is required to be conducted. Kindly have a look at page 89 once, my lord, which is the impugned order dated 26th of December 2023. The case is taken up for disposal. After perusal of the document, which is a receipt of the property tax taken by the Frejanganj Gram Panchayat, it is highly required to verify the authenticity of the said document needed to be supported by the auxiliary document. By verifying all the way around, the authenticity of the said receipt could not have sustained as it is not supported by any cogent evidence, either implicitly or explicitly. On the factual observation, the undersigned finds no other way but to set aside the application as it not fulfilled the parameters laid down in the Rule 166 of such and such of 1991.
এগুলো কিছু না প্রাইভেসি ডকুমেন্টস ওরা একটা এনকোয়ারি করে তো 166 এর ল্যাঙ্গুয়েজটা বলতে কি
Kindly have a look at the impugned order, my lord, passed by the my lord in way. I am placing, my lord, the relevant portion of the order, my lord.
Sorry, this is page
121.
120.
Kindly see below last paragraph in page 121, relevant portion. Yes. The principal contains an advance on behalf of the applicant is that the authority below failed to conduct an inquiry in the manner contemplated under the Rule 166 of the manual, and that undue emphasis was placed on the authenticity of the property tax receipt instead of the deciding the issue on the basis of the material available on record. It has further been urged that the Panchayat certificate having not been specifically disproved by the issuing authority, the collector ought to have accepted the same as sufficient proof of the existence of the structure prior to 24th of March 1986. Reliance has been placed upon the certain judicial pronouncement to contend that the official act carry a presumption of the regularity and that the tribunal is competent to entertain an application, notwithstanding the availability of the alternative remedy. Then it is the submission. Learned government representative on the other hand has supported the impugned order contending that the collector afforded adequate opportunity to the applicant to substantiate their claim. It is submitted that the applicant utterly failed to produce any reliable and the clinching material capable of establishing that the charge and the user has taken place 24th of March 1986, which is the foundational requirement under the Rule 166. It has also been argued that the impugned order is a well-reasoned one and the passed under due consideration of all the relevant material and that no interference is called for. Then we will kindly have a look at last paragraph, the observation. Therefore, the burden squarely lies upon the applicant. Where from he got it, I don't know. Who seeks the benefit of the such post facto regularization to establish the foundational fact by the producing cogent, convincing, clinching evidence. Mere assertion or the production of the isolated document of doubtful evidentiary value. Why it is doubtful, I don't know. Cannot discharge such burden. Settled principle of law, who he asserts must prove the onus embodied under section 101 and 103 of the Evidence Act. So, my lord, he applied the principle of onus provendi. And unless the claimant satisfactorily proves the fact and the claim rests, no corresponding obligation arises upon the authority to grant the such relief.
Next paragraph says the collector considered the said document caused verification to be undertaken.
Yes, this is the property tax receipt which I have submitted.
No, caused verification to be undertaken. That document.
No, nothing was there, my lord. In the present case, the applicant principally relied upon the old property tax receipt and the certificate emanating
from the reflection in the order that there was any verification done.
No. Single cryptic order, 4 lines order, my lord.
You have annexed the entire order sheet.
My lord. When it starts.
Yes, yes.
বইগুলো বার করো।
Yes, anything else, Mr. Dottu will go to.
My lord, I intend to rely upon 2 decisions, my lord.
Yes.
One is 2014 3 SCC 502. This is a known principle, paragraph 61. It is well settled that where the statute provided for a thing to be done in a particular manner, then it has to be done in that manner and no other in other manner. This proposition in laid down Taylor versus Taylor was first adopted in the Judicial Committee. Then, my lord, kindly see the next paragraph. The rule adopted in the Taylor versus Taylor is a well recognized and is founded on the sound principle. Its result is that if a statute has conferred a power to do an act, and has laid down the method in which that the power has to be exercised, it necessarily prohibits the doing of the act in any other manner than that which that has been prescribed. So, my lord, there is no, my lord, departure of the procedure which has been engrafted in the 166. Other, my lord, the provision, because there is a, my lord, the principle of duty to disclose. Since, my lord, opportunity was given to them, they did not file any objection, they did not disclose single document. Even after filing the supplementary affidavit, whether the document is wrong or authentic, single word has not been expended in the, my lord, impugned order. This is the document, this is the, my lord, the judgment relied upon on the principle of duty to disclose. Paragraph 27. 2022, 8 SCC 162. While the respondent, my lord, got it?
Yes.
Paragraph 27. While respondent,
Yes.
while respondent has submitted that the only material that have been relied on by the board need to be disclosed, the appellant has contended that the all relevant material need to be disclosed. While trying to answer the issue, we are faced with the multitude of the other equally important issues. These issues and all the paramount in the shaping the jurisprudence of the surrounding the principle of the access to justice and transparency range from the identifying the purpose and the extent of the disclosure required to balancing and the conflicting claim of the access to the justice and the ground and the public interest such as privacy, confidentiality and the market interest. Then 28.1.
Yes.
The reliability. The possession of the information by both the parties can aid to the court in determining the truth of the contention. The role of the court is not restricted to the interpreting the provisions of the law, but also determining the veracity and the truth of the allegation made before it. The court would be able to perform its function accurately only if both the parties has access to the information and possess the opportunity to address argument and the counter argument related to the information. Then 28.2, my lord, the fair trial. Since the verdict of the court has far-reaching repercussion on the life and the liberty of the individual, it is only fair that there is a legitimate expectation that the parties are provided all aid in order for them to effectively participate in the proceeding. Transparency and the accountability. All are, my lord, is the purpose of the duty to disclose.
This was a penal action under the SEBI Act,
Yes.
SEBI regulations.
Yes,
So
but the
that's why
principle has been called out that not only the
the
document
fair
which has,
trial and all these do not come in here.
my
This
lord,
is-
but the fact remains
Does that
that
have far-reaching repercussion on the life and liberty of the individual?
no. But the, my lord,
One, yes,
yes,
maybe.
but the principle which has been deduced therefrom is this, my lord, that, my lord, the not only the document which has been relied upon, apart from the all the documents, even if the document is favorable,
Part of natural
yes,
justice.
yes,
Or the alternate party, that's a
my-
part of
my-
what?
that's all, my lord. If
Yes,
there
Mr.
could be any query, my lord, I
No, my lord. As per my lord, this Land Reforms Act, my lord, there are two provisions. One is section 4C, which is permitted a person apply for conversion.
Yes.
Another is, my lord, section 166, which is, my lord, deals with the post facto conversion. Now, my lord, in this particular case, the petitioner obtained this property from his father in the year of 2015 by way of a, my lord, deed of gift. First, your lordship, kindly turn to page 43. The schedule of the deed of gift.
Yes.
মানে সেকেন্ড প্যারাগ্রাফ আরএস এবং এলআর সাচ নম্বর দাগে শালি মোট 42 শতকের মধ্যে বন্টননামা দলিল দ্বারা প্রাপ্ত যাহা অদ্য দানকৃত 10.5 শতক শালি বর্তমান বাস্তু। So there is no whisper that this is a doba or malad a water body. But the record of right shows that this is a doba / khal. Now, malad, there are two deed of gift.
But by then it was already converted.
Malad, I'll show. Now, malad, I'm just placing malad the some of the relevant parts from the records.
Yes, yes.
Now, malad, next malad, page 55. Which is another deed of gift to Gopal Sardar. The first one is also Malad Gopal Sardar, Manik Sardar, and the second one is also Gopal Sardar, Manik Sardar. Here, 5 শতক ডোবা বর্তমান বাস্তু। মানে দানকৃত তপশীল সম্পত্তির বিবরণ সেকেন্ড পার্ট মাইলার RS and LR 1681 নম্বর দাগে ডোবা মোট 10 শতক বন্টননামা দলিল দ্বারা প্রাপ্ত যাহা দানকৃত 5 শতক ডোবা বর্তমান বাস্তু। Now, my lord, kindly come to page 61. This is the statement of plan proposal of Malad proposed commercial 3-storied existing 2-storied hotel building plan of Mr. Gopal Sardar and Mr. Manik Sardar and Mr. Nirmal Sardar at Dag number such and such of district South 24 Pondra under Gram Panchayat. Lordship, kindly look at the bottom, the date. This is, my lord,
2016.
August 2016. So, as on August 2016, the land was recorded as Doba and
Doba Bortomane Bastu.
Bortoman Bastu, that is a physical part. But the record of right says that this is a Doba, that is a water body.
Is the reason they have applied?
I come to Lordship.
Yes.
This is a water body.
Yes.
And why I'm showing this, the next page will the answer. So in 2016, there is a 2-storied building. They applied for without even conversion under 166. This is a proposed hotel cum restaurant, this commercial 3-storied building. Now, page 62. They have initially not applied under section 166. They have applied under section 4C. So, Lordship, 4C.
But that is the language of 166. While disposing of a petition for conversion, it may come to the notice of the collector that the land has already been converted, and which was done in the present case also.
Kindly bear me 2 minutes. Well, I'm just placing the record. Then, I'll go to the statute.
No, not unnecessarily place record. I mean, we have to have a bearing.
This page 62, this is the initial application under section 4C, which is just first paragraph, my lord. I/we the honor to apply the permission for change or character, conversion or alteration in the mode of use of land having water body for the purpose of group housing. Now, my lord,
166 permits that.
Then, my lord, page 66, this is the report of the RI. Illegal filling of water body. Memo number such and such, consequent to the inquiry conducted by the concerned revenue inspector. Fezargon GP done accordingly as per above reference memo number. It is found that you have filled up a water body located at the under mentioned land schedule, and from the hearing as on 10/4/23 before the undersigned, it is now obvious that you have no sanction to do the same. In view of the above, you are here hearing directed to restore the water body.
But then you have to give a copy of the inquiry report to him. How can you controvert that? That's the basic cardinal principle of natural justice. Unless they have a copy of that inquiry report, how can they controvert that? Their documents are not touched. 2 property tax receipts showing that previously they had given property tax, the donor had given. Veracity we are not on. We cannot go into veracity. Maybe false document. But no reflection in the order. 4-line order without referring to even any inquiry report. We find from this that there was an inquiry. If there was an inquiry, yes, Mr. Bhattacharya, then the report has to be given to him so that he can controvert. Give a copy of the report to him, whatever documents he has given. Because apparently 166(1), the genesis can be an application for new conversion under section 4C. Apparently, while disposing of a petition for conversion, it may come to the notice of the collector. That is precisely what happened here.
Yes.
Collector did absolutely correctly. Directed it to be converted to 166 and then proceeded accordingly. But then you have to comply with 2 also. And 1 is the language should also be ascertained. It's like correction of records of right proceedings. You take report of the BLLRO. Similar.
Absolutely.
That exercise is not reflected in the order.
But my lord, kindly appreciate only one thing. Suppose, my lord, I have there was a water body which is in natural course, converted into
Filled up. Yes.
Filled up. Now, my lord, I applied before the authority. Authority, my lord, invoking 166 can convert it. But lordship, kindly appreciate the 2 dates. When they applied under 166, they applied under 166 in my lord,
of March 23, they applied for conversion. 4C.
Now, my lord, they applied under my lord, this 166 on 2nd of October 2023. That is also there, my lord, in their records.
If it's a 166 scenario, Mr. Bhattacharya, they need not file a further application also.
They have applied, my lord.
Should not, because of your direction, the ADM, DLR.
They have applied, my lord.
The court passed an order. Kindly have a
Court
look
passed,
at page
yes.
77.
Review rejected, but
Yes,
this
yes,
is comprehensive.
Now, my lord, the next one.
The court said that 160 has to be taken under 166.
No. Will kindly have a look at page 78. It will be open to the review applicant to raise all issues before the concerned authority in pursuance of the proceeding initiated under the West Bengal Land Reforms Act of 1955. It starts from page 77. Kindly have a look at page 78, the last paragraph.
Yes.
Prior to that, there is no error apparent on the face of the record. Therefore, no review. It will be open to the review applicants.
That is provided, sir, that provision is applicable.
Yes. Then will kindly have a look at page 79.
Let us, yes.
Now, my lord, kindly appreciate one thing, that this, when they have applied under 166 or even under 4C, it is not a, my lord, the bare land. There was a structure. There was a 2-storied building. My lord, and from 2016, my lord, there was a resort already, my lord, that was constructed over there.
That goes on to show that there was a previous structure already. So their case is prior to 1986, that structure was made. And
that is their case, my lord, and on the support of that, my lord, they have produced, my lord, that one
2 property tax receipts. They have produced 1 here also. We don't know, but this refers to 1. Let us suppose 1 even. So the minimum that the authority could do was to just have an inquiry as to that was a genuine document.
But as I find from the order of the DL and LRO, my lord,
because you are the state, you always have the resources to ascertain whether that property tax receipt is actually there in the department.
My lord, to be very fairly, my lord, that ought to have been done, my lord. Because, my lord, in 2023, my lord, as my lord, we have a little bit experience, my lord, it is not possible for a Gram Panchayat to authenticate,
Gram Panchayat, honorable Gram Panchayat, with all honor, and suppose all these documents are even fake, we are going to the ultimate limit. Suppose these documents are fake, photocopies without originals.
The state has to take, money.
Just see the records, and regarding that address, that area, that plot, you just ascertain from your records and reflect it in your, and whatever you rely on, take a report. That would be the best way to go. And give a copy of that report to them so that they can controvert whatever is there.
Then, my lord, in that event, my lord, if your lordship kindly grant us an opportunity to file opposition, my lord, to this application, we will bring the records.
No. This will be then the first forum which will be doing that. And we are sitting in appeal over OA. We cannot do that.
Or my lord, in that he will
We'll remand it and
remand, can you send back the matter to on remand, my lord,
yes.
with a direction upon the state, my lord, to file a report. If the state find necessary, we will verify the authenticity.
An inquiry may be done and a report be filed.
With
So
subject,
we'll come back to you. You're just exploring the options.
Because my lord, from page 89, the my lord, this ordering portion,
Yes.
I'm just find, my lord, that though
Nothing.
there is no specific averment as regards the authenticity of the report of the Fraserganj Gram Panchayat, but my lord, from the order it appears the concerned ADML disbelieved that and asked for the other ancillary documents.
But you are to, Mr. Dattu's argument is as per 166I. You are to
I
ascertain.
have to ascertain, my lord. I have to ascertain instead of asking
an
for
inquiry. And that inquiry was once done probably.
that was there.
So we don't know whether this
And that report has to be done to Mr. Datto's claim. It has to be made over to
he has to
Mr. Datto's
controvert
claim.
that. You have a fresh inquiry. This is also cryptic. This only says, no, this is to him. You have sent it to him. Consequent to the inquiry, you just let him know that you have filled up. This is the final probably.
Yes.
This is a communication of this.
Communication.
Post facto.
On 10th of March, on the basis of, my lord, after filing of their 4C application, on the basis of their inquiry, this
We'll just ask the DLR to comply with the principles of natural justice by giving you a copy of the inquiry report.
and also, my lord, to make an investigation as regards the authentic, because the state is the only authority who can
Is the repository of all the documents.
absolutely, and my lord, who
ultimately
can
information.
find out the authenticity of this, my lord, this certificate issued by the Gram Panchayat. This
Yes,
is my lord,
even Gram Panchayat.
surprising that the Gram Panchayat after 41 years giving a certificate that this tax receipt is the
Even if the Gram Panchayat, I mean, Gram Panchayat must be relying on records. So you have an inquiry on the records.
lordship.
Let us hear Mr. Dattu what he wants to say.
the document shown by my learned friend, page 66. This is the original document which has been, my lord, placed before the Honorable Division Bench in the public interest litigation. Consequent to the inquiry conducted, who conducted inquiry, how the inquiry has been conducted, whether this inquiry is...
Now, who is there? By the concerned revenue inspector.
Yes, who is there, my lord? Inquiry conducted by the concerned revenue inspector. No particulars, nothing has been mentioned. When nothing has been mentioned, Fraserganj Gram Panchayat done accordingly.
Yes, you see it. Yes.
Then, my lord, kindly see the difficulty is this. What is there, my lord? If the inquiry would be conducted de novo, whatever good, bad, indifferent, my lord, that would be done and it would be crystal clear. Kindly have a look at page 89. Even if your lordship, my lord, remand back the matter, that this order would be there, this order has to go. And, my lord, the way, my lord, in original application.
This is the order which we have to set aside.
Yes.
Otherwise, how can we
Yes, this order. And in that event, my lord,
in
that event, my lord, the ADMLR is the appropriate authority to take a decision de novo. It is not the, my lord, the learned tribunal, because he is the fact-finding authority. Your lordship has to remand back the matter to the ADMLRO so that after conducting inquiry, whatever, my lord, will come and that will decide once again.
Heard learned counsel for the parties. Footstop. Next para. The matter has a checkered history. Footstop. Shorn of unnecessary details, comma. The writ petitioners filed an application for conversion of the subject land from a water body to a hotel on March 8, 2023, comma, under the provisions of Section 4 capital C of the West Bengal Land Reforms Act 1955. First of next para. Subsequently, comma, a notification was issued by the state government for restoration of water bodies by demolition of structures. First up, next para. The matter came up before this court in a public interest litigation, comma, which was disposed of by directing the concerned authorities to take appropriate steps in view of such notification. Push up. A review application filed by the petitioners was rejected, comma, however, comma, with the liberty to the petitioners to file a comprehensive representation under the provisions of the 1955 Act. Full stop. next para, subsequently, comma, the matter went to the collector within bracket ADM and LRO bracket closed, who came to the conclusion that the proceeding was to be converted to one under Rule 166 of the West Bengal Land and Land Reforms Manual, comma, 1991, comma, it view of it having transpired that the land had already been converted to some other use than appearing from the records of rights. Full stop. Next para. The said proceeding ultimately culminated in an order dated December 26, 2023, whereby the collector within bracket ADM and DL and LRO bracket closed observed that after perusal of the documents, comma, documents produced by the writ petitioners, comma, which is a receipt of property tax, comma, it was required to verify the authenticity of the same and needed to be supported by auxiliary documents. So it was further observed that the said document was not supported by cogent evidence. On such premise, comma, it was held that the parameters laid down in Rule 166 of the 1991 manual were not fulfilled, and as such, the representation of the petitioner was rejected. Full stop. Next para, being aggrieved, comma, a challenge was preferred before the West Bengal Land Reforms and Tenancy Tribunal. Full stop. Next para. In the meantime, comma, the BL and LRO concerned passed an order for implementation of the order of the collector, against which a challenge was preferred by way of an interlocutory application in connection with the original application. Full stop. Next para. The same was initially rejected, comma, which was affirmed by this court. Full stop. The matter went up to the Honorable Supreme Court, which granted protection to the writ petitioners from demolition till disposal of the original application. Full stop. Next para. By the impugned judgment, comma, the original application has been dismissed. Full stop. Next para. The counsel for the petitioners argues that the learned tribunal shifted the cast the burden of proof on the writ petitioners, comma, by giving a go-by to the provisions of Rule 166 of the 1991 manual. Full stop. It is pointed out that in cases where it is found that the land has already been converted, comma, it should be inquired as to whether the change in use has been made in the usual course of nature or by deliberate action on the part of the applicant or any other person. Full stop. In the latter case, comma, it should also be ascertained whether the change took place before March 24, 1986, comma, that is the date of publication in the official gazette of the West Bengal Land Reforms bracket Amendment bracket close Act, comma, 1981. For some next para, clause Roman II bracket of Rule 166 provides that if the change in the use of land has occurred under the four circumstances enumerated therein, comma, the applicant should be informed that the change is being noted in the records of rights and the said record should be corrected accordingly in due course. Full stop. It is argued that in the present case, comma, the collector did not resort to any exercise of inquiry or obtaining a report to ascertain whether the change took place before March 24, 1986, and, comma, if so, comma, whether the criteria under clause Roman II of Rule 166 were satisfied. Full stop. Next para. Instead, comma, it is contended, comma, by a cryptic order, comma, the collector rejected the representation of the writ petitioners, comma, which was affirmed by the tribunal on an erroneous notion that the burden lay not on the respondent authorities to undertake the appropriate inquiry, but squarely on the writ petitioners to establish their case. Full stop. Next para. Learned counsel cites such and such reported at 2014 3 SCC 502 in support of the proposition that where the statute provides for a thing to be done in a particular manner, comma, then it has to be done in that manner and in no other manner. Full stop. Next para. Learned Counsel next cites such and such reported at 2022 8 SCC 162 for the proposition that the possession of information by both the parties can aid the courts in determining the truth of contentions raised before a forum. Full stop. Next para. These issues, comma, all paramount in shaping the jurisprudence surrounding the principles of access to justice and transparency, comma, it was held, comma, range from identifying the purpose and extent of disclosure required, comma, to balancing the conflicting claims of access to justice and grounds of public interest such as privacy, comma, confidentiality and market interest. Full stop. It is thus highlighted by learned counsel that disclosure of all information available to the parties is of paramount importance. Full stop. Next para. Learned counsel also lays stress upon the relevant observations made in paragraph 43 of the judgment dated September 22, 2025 in an earlier round of litigation, comma, where a coordinate bench of this court had observed that the tribunal shall proceed now that it will be open to both parties and the state to place all relevant documents, comma, if not already placed, comma, including the orders passed in the public interest litigation before the tribunal to facilitate a proper and comprehensive disposal of the original application. Full stop. Next para, it is argued that in the present case, comma, despite documents having been produced, comma, including property tax receipts prior to 1986, as well as panchayat communication by the panchayat indicating that the construction was made before the cutoff date stipulated in Rule 166, comma, those were not adverted to, or and no inquiry was undertaken by the collector to that effect. Push up next para. Thus, it is argued that the impugned judgment of the tribunal and that of the collector are vitiated. Push up next para. Senior standing counsel, comma, appearing for the respondent authorities, comma, places reliance on the documents on which the writ petitioners claim title. Full stop. It is sought to be pointed out that in the schedules of the gift deeds, comma, by dint of which the petitioners claim their title to the property, comma, indicate that the property that the land was doba and has currently been converted to Bastu. Full stop. Next para. Learned senior standing counsel also places reliance on a purported statement of plan proposal in respect of construction in the said property obtained by the writ petitioners, from which it is evident that the same was issued in August, 2016, that is much after 1986. Full stop. Next para. Learned senior standing counsel also places reliance on a communication by the BL and LRO, Namkhana, dated April 10, 2023, to the writ petitioners, annexed at page 66 of the present writ petition, from which it would appear that consequent to the inquiry conducted by the concerned revenue inspector RI Capital, done accordingly as per the memo number referred to therein, it was found that the writ petitioners had filled up a water body located at the undermentioned land schedule. Full stop. Next para. Thus, it is argued that an inquiry was actually conducted, which ultimately led to the rejection of the writ petitioners' representation. Full stop. Next para. It is further submitted that the veracity of the communication made by the Panchayat Pradhan is dubious, since the same was issued decades after the cutoff date, and as such, it is doubtful as to whether the said document could come to the aid of the writ petitioners at all in satisfying the criteria laid down in Rule 166 of the 1991 manual. Full stop. Next para. Learned senior standing counsel further submits that in view of the appropriate exercise as contemplated in Rule 166 having been complied with, comma, and the writ petitioners having failed to furnish any auxiliary documents in support of their purported initial property tax receipt, comma, the authorities were justified in passing the impugned judgments. For sub next para, upon hearing learned counsel, comma, the first thing which strikes the eye is that the exercise required to be conducted under Rule 166 of the 1991 manual is not of an adversarial nature, but is inquisitorial in character. Full stop. Next para, clause Roman I within bracket of Rule 166 stipulates that in cases where a conversion has already been made, comma, it should be inquired as to whether the change in use has been made in the usual course of nature or by deliberate action on the part of the applicant or any other person. Full stop. In the latter case, comma, the said provision enumerates that italic say it should also be ascertained. Eta italic say. তারপর এমনি whether the change took place before March 24, 1986. Full stop. Next para, the language used in the said provision is not that the applicant has to establish the fact regarding the change having taken place before March 24, 1986. Full stop. Of course, comma, we hasten to add that this does not mean that the entire burden is on the respondent authorities to come to a finding in that regard. Full stop. Definitely, comma, the applicant has to furnish some preliminary documents or material to initiate stroke trigger the inquiry in the first place. Full stop. Next para. However, comma, once some document is brought before the authorities, comma, it is the bounden duty of the authorities to undertake an inquiry and to ascertain whether the change took place before the cutoff date. Full stop. Next para, the provision further continues in clause Roman II thereof, which contemplates that if the change in the use of land has occurred under the situations as enumerated therein, comma, such as in the usual course of nature, comma, at a time when such change was not unlawful, comma, occurred due to developmental activities of the government or a local body in the surrounding area, or due to urbanization in the surrounding area, comma, the applicant should be informed that the change is being noted in the records of rights and the said record should be corrected accordingly in due course. Full stop. Next para, as per the said provision, comma, it is further required that if there was a reasonable cause made behind the change that occurred, comma, the collector double inverted may consider on the merit of the case double inverted clause if post facto permission should be granted. Full stop. Next para. Thus, comma, an elaborate exercise is contemplated in clauses 1 Roman I and Roman II of Rule 166 on the part of the authorities at two phases. Full stop. However, comma, in the present case, comma, we find that nothing is reflected in the order of the collector as to such exercise having been undertaken. Full stop. Next para, as laid down in Deepak Babaria Supra, comma, relied on by the writ petitioners, comma, if a statute provides for a thing to be done in a particular manner, comma, it has to be done in that manner and in no other. Full stop. Next para, although there is some doubt as to how far T. Takano Supra is applicable in the present case, comma, since it was a case where a penal measure had been taken under the SEBI regulations against the appellant therein, comma, in which context, comma, the Honorable Supreme Court was considering the verdict of a court having far-reaching repercussions on the life and liberty of the individual, comma, which is not the case here, comma, fact remains that the provisions of Rule 166 themselves clearly enumerate the course of action to be taken by the respondent authorities. Full stop. Next para. Moreover, since the effect of rejection of an application for conversion would have a material bearing on the applicant, valuable rights might have accrued in whose favor in the meantime, before coming to a conclusion, an appropriate opportunity of hearing has to be given worth the name to the applicant, at least by furnishing all documents, including inquiry report, to the applicant to meet those. Full stop. Next para, without such opportunity, if an order is passed rejecting the application, it would squarely hit the principles of odi alteram partem. Full stop. Next para, thus, in the present case, the learned tribunal erroneously placed undue stress on the principle of burden of proof by a person which asserts a fact, by overlooking the paradigm of Rule 166 of the 1991 manual. Full stop. Next para. Accordingly, WP LRT 147 of 2026 is allowed on contest, thereby setting aside the order, the judgment dated July 15, 2026, passed by the which bench? Third, thank you. Third bench of the West Bengal Land Reforms and Tenancy Tribunal in OA number 61 of 2024, bracket LRTT, as well as setting aside the order dated December 26, 2023, passed by the collector within bracket additional district magistrate and district land and land reforms officer, South 24 Parganas, in respect of file number 59 within bracket capital C bracket close stroke 351 stroke capital P stroke 2023, and remanding the matter to the collector bracket ADM and DLRO bracket closed for undertaking a fresh exercise of inquiring into the veracity of the documents furnished by the writ petitioners before the collector. Push up. While doing so, an inquiry shall be undertaken by the collector with regard to the parameters laid down in Rule 166 of the 1991 manual vis-a-vis the writ petitioner's application for conversion. Full stop. Whatever documents shall be relied on, documents and other materials are intended to be relied on by the collector in coming to the ultimate conclusion shall be furnished to the writ petitioners in order to enable the writ petitioners to controvert the same and put forth their version on the same, if need be. If need be, full stop. Version of the same. Full stop. Next para. It is expected that such exercise shall be undertaken as expeditiously as possible. We have set aside, so there is no scope of implementation now. Yes. Thank you. Very good. Done. এটা চলে কাগজ একটু এরকম আমরা ঘুরে আসছি
Item number 7.
We find from the records that the petitioner has been repeatedly absent at the time of call. Full stop. Next para. এই সবকটা pending, সবকটা can. Accordingly, যা যা can আছে are dismissed for default without an orders to cost. দুটো আগে চান্স দিয়েছি। হ্যাঁ দেখলাম লাস্ট দেখলাম।
Item number 8.
হ্যাঁ
My
Yes.
application. In an appeal from a decree passed under the Land Acquisition Act for enhancement of compensation. The compensation was enhanced.
Yes.
As condition for stay, the state has deposited the money before this court. This is my application seeking withdrawal of a part. Now, on the last occasion, I had pointed out to your lordship, I had pointed out to your lordship that this was a bunch of cases where contiguous land was acquired by the same notification under section 4 and declaration under section 6. Several persons applied for enhancement. All decreed. An appeal, one of the appeals has been disposed of by this honorable court upholding the decree and affirming the judgment of the court below. So, my lord, nothing really survives in the appeal. The appeal itself will have to go. The learned senior standing counsel can consider this and come back, my lord, because he should not be
No, but
taken by such.
Mr. Bose, how was it done by learned single judge? Oh, sorry. Chief, Chief, yes. Yes, very good.
My difficulty is that I have only the application, not the copy of the paper book of the main matter, or
Paper book has not been filed by the state.
or even the memo of appeal or the
I will
connected.
supply the memo of appeal.
If you can
With that,
supply,
we'll
I
keep
can
it next week. We'll keep it next week. You
go
take
through it
form
and
your
we'll-
independent opinion, Mr. Bhattacharya. Learned counsel for the respondent submits at the outset that that although the present application has been filed for withdrawal of the deposit made by the appellant stroke state, comma,
একটা set আমাকে পাঠিয়ে দিও, আমি
a
দেখে নেবো।
similar challenge by another land loser, comma, arising out of an acquisition proceeding of an adjacent land,
না, না,
comma, out of the self-same acquisition proceedings, comma, was dismissed, comma, thereby affirming the judgment of enhancement passed by the reference court. Push up a copy thereof, comma, in the matter of land acquisition collector versus Akshay Kumar Khamrai, reported at 2022 SCC Online Cal 4141, is cited by learned counsel for the respondent. Push up next para. In order to enable learned senior standing counsel, comma, appearing for the state, comma, to apprise himself of the said circumstance and the judgment in which a similar matter was already disposed of, comma, let the matter stand adjourned till August 17, 2026, when it will be listed under the same heading. Let it appear under the heading application. If necessary, we'll dispose of it.
Item number 9.
I am
Yes.
respondent.
This is my appearance connected stay application.
Yes. This is against what?
Your Lordship will recall, Your Lordship, I'm being led by Mr. Rajushi Dotto. This is
Yes.
regarding Shahu Samaj Trust West Bengal
Yes, yes.
and Shahu Samaj Trust. What has happened, Your Lordship, the impugned order has been passed in an injunction application filed by the defendant in my suit, where the defendant has no counterclaim whatsoever. So the first question, Your Lordship, which Your Lordship has also recorded in the last order granting injunction to us, is whether at all it is permissible for the learned court to grant an injunction when, or whether the defendant had any locus to file an injunction application in my suit. Your Lordship, in this
So
regard,
as a matter of law,
Yes.
defendant, there is no bar in the defendant filing an application.
Your Lordship will
Any party can file an injunction application in a
Your
suit.
Lordship, only when the caveat is that only when the property in dispute is a subject matter of the suit.
It has to be in aid of the
Absolutely.
final.
So first of all, Your Lordship, there is no relief claimed. Even if I consider Order 39 Rule 1, where any party can file an injunction application, it has to be in respect of a property directly in dispute in the present suit. So in that regard, Your Lordship will kindly take up the plaint and the prayers, whether or not it forms a dispute. Your Lordship, the plaint is appearing at page 108 to 120 of my stay application. The prayers start at page 116. We had filed a suit for declaration and permanent injunction, stating that the present body elected is the duly elected body, and since the defendant, number 2, had been representing himself as the chairman of the trust, Shah Samaj Trust West Bengal, we had sought for an injunction against them and directions upon the bank to permit us to use our. Your Lordship, the prayer started page 116 of my stay application. So if this be the scope of the suit, Your Lordship will kindly have a look at Order 39 Rule once. Order 39 Rule 1. If I may place it, Your Lordship. Where in any suit it is proved by affidavit or otherwise, A, that any property in dispute in a suit is in danger of being wasted, damaged, or alienated by any party to the suit. Here the word, of course, any party is used. Or wrongfully sold in execution of a decree, or thereafter the defendant threatens such and such, defendant
The
threatens
suit
such.
is a sine qua non.
Yes, absolutely. Now, if this be the position, Your Lordship has seen the prayers already. Now, Your Lordship will kindly have a look at the impugned notice which has been stated, which is dated 7 September 2024. The operation of this notice was stayed ultimately in the injunction order. So, Your Lordship, this notice is appearing at page 121 of my stay application. The translated copy, the actual copy, Your Lordship, is not legible even for us. So, whatever the translator has been able to translate.
Our copy is better than yours then. A little bit better.
Your Lordship.
Anyway.
At page 121.
Yes.
Your Lordship will see the agendas which have been proposed to be discussed in the upcoming annual general meeting of the Trust, West Bengal. First is to consider and pass accounts of trust for the period commencing from such and such. Second agenda is amongst the trustees a new trustee body for
to elect stroke select.
To elect stroke select, yes.
The
third is from among the trustees to elect or select the chairman, vice chairman, one secretary, such and such. Fourth is the agenda item based on which the injunction order has been passed, which is to demolish building and to construction of a new building at premises number such and such, which is the premises which is in occupation of Shah Samaj Trust, West Bengal.
So this was a notice for convening a meeting where these will be decided.
Well, it will be decided upon. These agendas will be considered.
Not yet decided now.
Not at all decided. Not even the meeting itself was injuncted upon. A blanket stay has been issued on this notice without any finding as to whether or not the issuance of this notice had any illegality perpetrated. So, nothing. And the scope of the suit, again, Your Lordship, if I may, Your Lordship has seen the press, the scope of the suit is very limited. It is declaration that I am the duly elected body of members and an injunction upon them from representing themselves as the chairman. Now, Your Lordship will kindly look at the impugned order.
Yes.
The impugned order is at page 15. 15 of my stay application.
The caption is under 151.
Yes. Your Lordship, again, in this regard also has...
No, yes, it's settled. It's settled. But your injunction is still pending. You had also filed an injunction?
We had not filed an injunction.
You didn't file
Your Lordship,
may or may not be very.
But be that as it may, they have filed
Injunction application is pending.
Their injunction also.
Their
Be that as it may, Your Lordship, what we are here under is the order passing their injunction application.
Yes.
And Your Lordship is aware that 151 can only be exercised when not expressly provided under Order 39 Rule 1, which is provided. Now, Your Lordship will kindly have a look at the impugned order at page 15 of my stay application. Well, Your Lordship, the relevant portion
is from page 18. If I may kindly place your lordship, page 18 of my stay application. 1-8. Internal page number 2, if your lordship has the memorandum.
Yes. The impugned order is dated 27th of September.
Yes, 27th September
Yes.
2024. Your lordship, I'm placing it from the third line, which is the paragraph. Shahu Samaj Trust, West Bengal. It begins as Shahu Samaj Trust,
Yes,
West
yes.
Bengal. Shahu Samaj Trust, West Bengal and Shahu Samaj Trust are different. Shahu Samaj Trust has no movable or immovable property except a sum of 20,000 in cash. There are two separate letterheads for the two trusts since after purchasing the trust property at such and such. On 25th February 1981, property tax has been paid to the KMC. When defendant number 2 noticed that the Shahu Samaj Trust was trying to grab the immovable and movable assets of Shahu Samaj Trust West Bengal, and the trustees changed the letterhead from Shahu Samaj Trust to Shahu Samaj Trust West Bengal without the consent of the trustees, he, on protest, tendered his resignation from the post of vice chairman of the said trust executed on 21st February 2018. Your lordship will recall in this regard there was a dispute whether or not he had actually tendered his resignation. So, our stance is that he had tendered his resignation from the post, but later on we have co-opted him as a trustee, so we are not pressing that point as such. Thereafter, your lordship, I continue. Shahu Samaj Trust, with ill motive, was trying to sell or develop the property of Shahu Samaj Trust West Bengal and issued public notice through daily newspaper Sunmarg on 8th December 2019. The present plaintiffs have no right to proceed with the trust property of Shahu Samaj Trust West Bengal as they are not trustee, not holding any post. Defendant number 2 is still holding the post of chairman and running the trust under the name of Shahu Samaj Trust West Bengal. This was the submission made by the defendant number 2, that he is still the chairman. On 18th August 2024, the defendant number 2 came to know that the plaintiff number 3 issued a notice by changing letterhead format for holding general meeting to be held on such and such for the purpose of election and to resolve to demolish the existing building and reconstruction of new building at the premises number 108/6 SN Banerjee Road, which is apparently his main grievance. The present suit is pending for determination who are the real trustees of Shahu Samaj Trust West Bengal. If the plaintiffs succeed to hold the meeting and demolish the existing structure, irreparable loss and injury would be caused to the trust and the defendant number 2. The defendant number 2 pays for staying of operation of notice dated 7 September 2024. Plaintiffs in the written objection denied and disputed such and such. Thereafter, your lordship turns over. It is ordered that. Sorry?
No. Previous page is the next page.
Huh?
You have read page 2.
Oh, yes.
Prior to that, page 3.
I apologize, your lordship. Was duly accepted. The defendant number 2
is about the resignation.
Yes. Thereafter, your lordship will come to the bottom. Last paragraph, your lordship. Rights of the parties are to be determined in trial on evidence. If the trust property is demolished, pending that determination of the rights of the parties and the defendant number 2 succeeds to establish his right in trial, it would be a great difficulty for him to restore the original state of affairs. In the circumstances, the application is allowed and it is directed at page 19, your lordship, that the operation of the notice is stayed. So, your lordship, I do not wish to advise my learned friend, but at best what he could have done is file a separate proceedings. He cannot intervene in my suit, which is solely for declaration and injunction upon him from representing himself as the chairman before the bank and before everybody else. And file an injunction and obtain a stay on the meetings that are supposed to be held by the trust. And even with regard to whether or not he's a chairman, your lordship will kindly look at the fallacies in the document that he himself has disclosed. In his opposition, your lordship, affidavit in opposition, he has disclosed certain minutes of meetings which purportedly represent himself to be the chairman as if he has been elected as the chairman. The lordship, the flaws I have stated in my affidavit in reply, your lordship will kindly have a look at my affidavit in reply, paragraph 14. And with that, your lordship, I will keep the minutes of the meeting side by side. The minutes of the meeting appear at page 84 of his affidavit in opposition. Lordship has page 84 of his affidavit in opposition.
Yes.
Yes. Your Lordship will kindly see the following was discussed and decided to act upon. The first agenda, immediate registration of our trust must be done with the registrar of Assurance West Bengal. Your Lordship, admittedly,
This was the previous,
this is with regard to How Much Trust West Bengal, which was in 1981 and registered in 1981 as well. And this is an admitted position not only in his affidavit in opposition, but written statement and every single pleading that he has made. He specifically admitted and has given the registration number of the trust, which has been registered in 1981. So at best, he's either this entire minutes is fabricated or he's trying to create another trust with the same name. It cannot be that today, for a trust which is registered in 1981, admittedly, he proposes to vote upon another agenda for fresh registration of the same trust. Your Lordship will see the admission. The admission is there in his, at paragraph 10, pages 11 to 12 of his affidavit in opposition. Your Lordship will kind of come to page 11.
Yes.
If I may place, with reference to the statements made in paragraph 3, subparagraph 3 of the said application, are matters of record, and I deny and dispute each and every allegation which are contrary thereto and are inconsistent with the record. In this connection, I state that though I have not been elected any post of office bearer, but I was and am continuing as an ordinary trustee of the said trust, my trusteeing is lifetime. And this is a specific stance. He was originally the chairman of the 1981 trust deed, not in dispute. But since the elections which took place in 2011, he has not been elected. He contested for the elections took place in 2011. He failed. He refused to sign in those minutes. And thereafter, he has not been elected. Not even once.
Yes. Anything else, Mr.
Your Lordship,
We are hearing him.
yes. Your Lordship, primary, these are my grounds. First and foremost, there is no illegality in the passage of the notice dated 7 September 24. Second is, Your Lordship, there was no reason for passing blanket order of stay. Third is, Your Lordship, that for the defendant to make an application of injunction, it has to be regarding a property which is directly in dispute in the suit. The scope of the suit is not wide enough for that. And fourth, Your Lordship has seen prima facie, at least the documents show that the minutes disclosed by them are fabricated and they have not been elected as a chairman since 2011. They are misrepresenting themselves to be the chairman of the How Much Trust West Bengal, constituted in 1981 before authorities, including the bank. And Your Lordship, these are all agendas which are to be voted upon. There is no illegality in passing or issuing a notice proposing to discuss certain agendas and vote upon those agendas.
As a trustee, he's also entitled to participate in that.
Yes, we have co-opted him as a trustee. We are not pressing that stance anymore.
He's also entitled to participate in that meeting.
Yes, of course, he can vote if he wants. He has not been participating voluntarily.
That's different. Let us come to it. Yes.
Oh. Lordship, if I may have leave, Your Lordship wanted to have a look at the original of his resignation that he had purported to have been made to How Much Trust.
That's a part of the record, otherwise.
There is a Xerox copy is a part of their affidavit in opposition.
I keep it with you for the timing. Yes.
Right.
Yes.
My lord, there are two registered deed of trust. One executed in the year 1981 and another executed 2018.
2018.
2018.
Sorry.
But in the plan, they have not disclosed that there are two trustees. According to us, the plaintiffs are the trustees of the trust deed executed on 2018. The defendant number 2 was the settler and founder of the trust executed on 1981. Now kindly see the plane, page 108. Now kindly come to page para 10, page 112. I am reading that from the records of documents of the said trust, it is clear that the defendant number 2 was the chairman of the said trust at time of formation of the said trust deed, but subsequently he was not elected as chairman of the said trust in the election held and are conducted by the special officer appointed by the High Court at Calcutta in 2011. And now he is continuing as an ordinary trustees of the said trust. They admitted in the plain. But when they submitted before my lord, they are submitting that he is gone.
What have they admitted?
My lord,
They are saying what they are saying now also.
at the
Defendant
plain,
number 2.
at the plain.
They are saying the defendant number 2, you are the chairman, you are no longer
Yes,
the chairman.
I am the defendant number 2.
You are now an ordinary trustee. That is what they are saying.
No,
You also admit that in your opposition here.
no, it is their plain.
They allege that you are only a trustee, no longer a chairman. In your opposition, which was placed by your
My lord,
friend,
their intention to
please come to page 11 of your opposition, filed here, para 10. It's a separate assertive statement, affirmative statement. The last sentence. In this connection, I state that though I have not elected any post of office bearer, but I was and I am continuing as an ordinary trustee. So you admit that?
I admitted. It is the fact. But they are stating.
They are also stating the same thing.
No, my lord. They are stating that I have tendered my resignation. Then I have no.
All right.
I have no post. They are again and again showing my lord.
Whatever. It's admitted that you are no longer a portfolio holder.
No, but I am the
trustee.
Lifetime trustee. They are denying.
All right.
They are denying. I am the lifetime trustee in respect of the trust which was executed in 1981.
What is your grievance against the notice? Why is it bad?
My lord, they suppress the thing that they are the trustees of the second trust. In the plain, they have not disclosed. They have not disclosed that there are two trusts. As if there are one trust. And I tendered my resignation, then I have no. It is their contention. My lord, it is clear, my lord.
According to there is only one trust of 1981.
Yes. But they have suppressed that there are another trust. In the plain, in the stay application, nowhere stated.
But it's an admitted position that they are the portfolio holders now.
There.
You are not the portfolio holder of any of the trusts now.
No.
Trustee. You say you're a founder trustee.
I am the portfolio at present. I am the portfolio of the trust which Sahu Samaj Trust West Bengal. And he is the trustees of Sahu Samaj Trust, which was second trust. It is the second trust. I am the, but yes. I tender my resignation in the from the second trust.
But you are still, you say you are a chairman of the previous trust.
West Bengal. Sahu Samaj Trust. Still dead.
So you are not merely a trustee in respect of 1981, West Bengal. But you are a
2 years
chairman also.
My portfolio is 2 years now.
So that's over now.
2 years over.
So what is the
then
wrong
I
in
came.
What is the wrong in the notice? It does not
If
infract any
they,
of the provisions.
If they
yes.
able to demolish that existing structure if they is able to develop or to sell out the trust property, I will suffer.
You have not stated that they have violated any of the articles or whatever provisions of the trust. You have stated only that if they are able to demolish, then you will suffer. The trust will suffer. Appreciated. But this is premature. This is only a notice to hold
They have no connection.
hold a meeting where it will be decided whether it will be demolished or
No, they
If the
have not.
majority, if the majority decides
No,
it will
they
be
have
demolished.
not yet.
Sir, please. If the majority decides it will be demolished, then how can we have a stay on the notice of meeting?
My lord, they have no connection with the first trust. First trust have trusted property. Second trust has no property. But they are grabbing the property of the first trust. No, without determination in the trial. It will not be solved. My lord, kindly send the matter to the trial court and direct them to determine who are the trust.
Your application under 151, where have you stated these things? Show us that portion. Because you don't find any determination on this in the impugned order also. There is no reflection of these things in the impugned order. First trust, second trust.
Yes, yes, yes. কোনটা পাওয়ার তো? হুম। আমাদের
Yes.
On page 122.
Yes.
This is my application.
Right. Page 123, para 6.
6. That one trust was registered and executed on 25th of September 1981 before the Registrar of Assurance, Calcutta, pages in the year 1981. In the aforesaid deed of trust, 28 members were appointed as trustee. The defendant number 2, Thakur Prasad Gupta, is one of the settler and founder member of the trust. The defendant number 2 was also appointed as one of the trustees in the aforesaid trust. The said trust is known Sahu Samaj Trust, West Bengal. It is pertinent to mention herewith that all the 28 trustees have deposited a sum of rupees 10,000 in each trustee for progress and fulfill in the objects of the trust deed. It is mentioned here that another trust deed was executed 21st February 2018 before the Assistant Registrar of Assurance, Calcutta, white book number also pages from. So, being trusted for the year 2018. It is also mentioned here with that in the said trust, the defendant number 2, Thakur Prasad Gupta, is one of the settlers and founder of the trust, and he is also one of the trustees. The name of the said trust is Sahu Samaj Trust. The object of the trust is to create to establish a public trust. My lord.
Excuse me, sir. Can you show that where have you stated regarding the illegalities in the notice in this application?
On para 8 and para 9 and main para 10. Para 8, para 9, para.
You are hitting at the very basis of the notice because you say that 1981, they don't have anything to do with the 1981 trust.
My lord?
You are saying that they don't have anything to do with the 1981 trust.
Yes.
They are not trustees, you are the chairman still, and they are trying to mix up the two. This property belongs to the
Yes,
1981 trust. Therefore, the basic foundational authority to issue a notice, they don't have. That is your primary problem. The notice itself is vitiated because they don't have the authority.
Illegal notice.
You are still the chairman, and resignation was you deny the resignation.
Without their authority.
No, resignation you deny that you have given or they have not accepted. What is your case regarding resignation?
Resignation, my lord, when the defendant number 2 observed that the trustee of the second trust deed are trying to grab the property of the first trust deed. First trust deed has property at the SN Banerjee Road. Second trust deed has no property, only 20,000.
You resigned from what? The second trust?
First, 1981.
You resigned from there?
1981.
You resigned?
Second trust.
That is what you are asking.
Wait, second trust I resigned. Second trust, this Sahu Samaj Trust, not West Bengal. I am
Yes, that
the
you are.
post Sahu Samaj Trust, West Bengal.
But they are here plaintiff, they are trying to represent House Samaj Trust West Bengal only, which is of 1981. Yes, anything else you want to add?
My lord,
You want to add anything?
my lord, it is my humble prayer. This is the trust property. Without determination, who are the original trustee? My lord, kindly restrain them not to demolish, not to develop, not to.
They have not yet decided to demolish. It's premature now. Why are you apprehending? They have given a notice where a meeting
They are
will
trying to, my lord. They issued notice to demolish the trust property.
The cause of action is not proximate. They want to hold a meeting. You have not pointed out, apart from their not being trustees.
My lord, page 129.
That is one of the agenda in the meeting.
121.
That's
right.
only an agenda in the meeting. You participate in the meeting and resist that.
No,
What no?
they have not intimated us.
If you want, we can observe that you can participate there.
My lord, they called for meeting from the second trust. I am holding, till date I am holding the first trust deed.
If they called for a meeting in the second trust and you have resigned from the second trust,
Yes.
what is your cause of action?
Second trust has no trusted property. They're trying to grab the property of the West Bengal Trust. It is their intention. It is their real motive.
This is that impugn notice. This. Where is
121.
121.
It is type copy.
Yes, 120 is the main.
121.
Yes,
121. It is the notice. Next page, type copy.
Yes, we.
My lord, kindly see their prayer.
They have seen their prayer. They placed it at the first.
Declaration that the present executive committee of the said trust duly elected in the election held at the annual general meeting of the trust on 10th November 9 is illegal, valid and operate. But they are also who determine manner without trial. It will not be determined who are the real trustee. Kindly direct the trial court to determine who are the original trustee. That will solve all the
Yes, any reply, Mr.
Your Lordship will kindly permit my leader.
Yes, we are. We are asking.
My lord, only kindly takes note of page 83, the minutes of the meeting. This is in respect of Shahu Samaj Trust, West Bengal, where my learned friend was present. My lord, this is a meeting of 2011 which was held, my lord, pursuant to an order passed by this honorable court in another proceeding, because the election of the committee was required. The lordship will take note of only one paragraph at foot of the page 85, my lord. Mr. Thakur Prasad Gupta, my lord, who is, my lord, the defendant number 2 in the suit, after perusing the list, agreed to the names proposed as chairman, vice chairman, assistant secretaries, treasurer. He, however, expressed his desire to be himself appointed as secretary and appealed to the trustees and the additional trustees present in the meeting to elect him as trustees. The appeal made by Thakur Prasad Gupta for electing him to the post of secretary was placed at the house for voting. The trustees and additional trustees present by show of hands elected HON'BLE Prasad Gupta as secretary. So he was not. Since 2011, he is no longer an office bearer. The issue before the learned trial court was whether he had resigned or not. My lord, there is a letter of resignation, but without going into that, my lord, if I heard your lordship saying, even if he wants to participate in that meeting where the agendas are there, we really don't have an objection. Because we have co-opted him as a trustee in a subsequent meeting, we will allow him to, my lord, participate and vote on those agendas.
They have a foundational objection, Mr. Dattu, in as much as they say that you are not trustees or.
My lord, this is the document by which we were appointed. And why did I file the suit for declaration? My lord, kindly takes one letter which they had addressed to the bank, my lord, trying to stop the operation of the bank accounts. My lord, kindly comes to
1981 trust has all the properties.
1981
and
trust.
You are trying to confuse that with the 2018 trust.
No, I am not.
You are trustees of 2018 only.
My lord, kindly seize my plaint then. There was a purpose behind institution of this.
About the property being regarding the property, have you stated anything in your plaint?
In the plaint? No, my lord, my plaint was only in respect of a declaration that we are the validly elected body.
Your suit, the subject matter is whether you have authority, you are now the office.
Whether I am the elected body or not.
Elected body, validly
Yes.
elected body.
And I also, my lord, challenged, my lord, action of the, my lord, the defendant number 2, because he had written to, my lord, the Allahabad Bank trying to stop operations of the bank account of the trust. Kindly takes note of the, my lord, reliefs claimed in my suit. My suit is very simple. It is 81 trust. 81 trust has the properties. We are the elected body of the 81 trust, but there is interference at the instance of defendant number 2.
The properties have you stated anywhere?
My lord,
probably not.
I'll just
check.
Since the property was not the subject matter of the dispute, it was only the bank account then. So, my lord, we restricted it to the bank account in the body of the plaint. Paragraph 11 is, my lord, really the paragraph. I want to, my lord, show only one more paragraph apart from 11. Kindly see para 10 at page 112. From the records and documents of the trust, it is clear that defendant number 2 was the chairman of the trust at the time of formation of the trust deed, but subsequently he was not elected as chairman of the trust in the election held and or conducted by the special officer appointed by the Honorable High Court at Calcutta in 2011. This is the meeting which I showed, my lord. And now he is continuing as an ordinary trustee of the trust. So in my plaint, I admit that he is continuing, so far as 1981 trust is concerned, as an ordinary trustee. Then, my lord, para 11. At all material point of time, plaintiff number 1 maintained current bank account bearing so-and-so with Allahabad Bank, now so-and-so, and guideline by RBI as well as Government of India at present said Allahabad Bank merged with Indian Bank. So this is my bank account. Then, my lord, where is the interference? Kindly sees. Kindly comes to page 114. Well, in fact, it starts at 113, my lord, para 13. After formation of the present committee through annual general meeting held on 19th November 2019 of the plaintiff number 1 trust and the present elected executive committee members are very much surprised to know that defendant number 2 allegedly claimed himself as chairman of the plaintiff number 1 trust, taking advantage of old office bearership to the post of cashier and secretary, but lost his candidature in 2011. And approached the defendant number 1 bank authority for operating of the said current account of the trust bearing number such and such, which however was not allowed by the bank. Now let me show this letter, my lord. Kindly comes to page 107, my lord, of my application, my lord. The typed copy is at 107A. My lord, Allahabad Bank is writing this letter to the Deputy General Manager, Allahabad Bank, regarding the status of Shahu Samaj Trust account. We have to draw your kind attention that we have sent captioned account for transformation from operative to inoperative to operative with a letter dated such and such along with original account opening form so and so. In this circumstance, one of the trustee, Thakur Prasad Gupta, declared himself as chairman of Shahu Samaj Trust West Bengal, account number so and so, and complaining about other group of personnel approaching the bank to make operation for captioned account with a letter dated 19th November 2019. This is the one which is referred in para 13 of my plaint. So he was trying to, my lord, represent that he is still the chairman of the 1981 trust, despite, my lord, the 2000 after the 2011 meeting, which I have disclosed the minutes, he was never appointed as any as an office bearer of the trust. He was simply an ordinary trustee of the trust. Now, my lord, after this letter, my lord, we institute the suit, my lord. At page 108, the plaint starts. Kindly takes note of relief, my lord, C. Because relief B is a declaration that we are the elected body in terms of the 2019 meeting. Now relief C. Permanent injunction restraining my lord, it's at 117. Permanent injunction restraining defendant number 2 from creating any obstruction or hindrance in any manner whatsoever in smooth functioning of the trust by the duly elected office bearer of the trust, and also for operation of current bank account number so and so, previously Allahabad Bank and presently Indian Bank, maintained by the trust. So my suit as framed has got nothing to do with the 2018 trust. But in the 151 application, my lord.
No, your suit is premised on his resignation also. Does he deny his resignation?
My lord, kindly sees, my lord, I have not really asked for any relief qua his resignation. And today I am not. My lord, I will be very candid before your lordship.
He has not resigned. Then you don't have the authority.
No, if he has not resigned as a trustee, ordinary trustee only.
Chairman.
No, my lord, he was never. After 2011, he was not there. Kindly see para 10 of my plaint. Kindly comes to page 112. And then I will, my lord, refer to the affidavit in opposition which Mr. Bhattacharya showed your lordship, that he admits that he is only an ordinary trustee. So, my lord, from 2011, there was no, my lord, question of him holding any office. In 2019, there was again a meeting where we were, my lord, declared as the elected office bearers. Despite that, my learned friend's client writes to the bank saying that I am the chairman of the Shahu Samaj Trust West Bengal, the 81 trust. That prompted us to go to the, my lord, city civil court and file a suit seeking a declaration we are validly elected body and seeking a permanent injunction relief that you cannot interfere with the operation of the bank account. Now, what does the learned judge do, my lord, with the impugned order? He has really expanded the scope of the suit, because in his 151 application, my lord, this 2018 trust fact has come in. My lord, the 2018, my lord, trust, Shahu Samaj trust, which has come in, it is only because of his application. My suit, the circumference of my plane does not, my lord, really concern the 2018 trust. When he brings this, he tries to give an impression that no, the elected body is of the 2018 trust, but they are trying to dispose of assets of the 81 trust. This is the impression which he gives, and tries to, my lord, get a stay on the, my lord, meeting which was proposed to be held pursuant to that notice. Now, I had shown, my lord, when I moved it initially from the, my lord, clauses of the trust deed, none of the application does not say under what ground it is violative of any of the clauses of the trust deed, the 81 trust deed. And, my lord, if lordship sees the notice, what are the only agendas that are to be, my lord, discussed in the meeting? Kindly comes to 121, my lord. First is, my lord, to consider and pass accounts of the trust. Second is, my lord, new trustee body formation in terms of the deed of trust. This is, lordship will find, kindly takes a note at page 68. This is
Primarily aggrieved with 4.
He's primarily aggrieved with 4. Now, this, my lord, is Shahu Samaj Trust West Bengal's notice. Now, his application proceeds on the premise that the persons who are trying to deal with the property in this meeting are persons who are representing themselves to be the office bearers of the 2018 trust, which is Shahu Samaj Trust. And by confusing, my lord, my learned, possibly the learned judge, my lord, understood it in a different manner and thought it fit that a trust property cannot be sold in this manner. But, my lord, 3 submissions, my lord, I make. One, there is no illegality which is pointed out in the application to show that these are the clauses which are violative, the notice is violative of these clauses in the trust deed. That is not there in the application. 2, a written statement has been filed by the defendant number 2. There is no counterclaim. In my suit, can he file this application and seek a stay of, my lord, a meeting where, my lord, only agendas are to be discussed? 3, my lord, whether, my lord, as a only ordinary trustee, my lord, he can, my lord, stop a meeting of the, my lord, trust, which is being held pursuant to the, my lord, clauses which are there in the trust deed itself. My lord, so I say, my lord, the order, my lord, deserves to be set aside. Lordship had initially, my lord, given us this protection by staying it, my lord. I say, my lord, kindly, now nothing survives, my lord. Appeal has itself been heard, my lord. Kindly set it aside, my lord, and we can go back to the trial court.
The present appeal has been preferred against an order whereby on an application purportedly captioned under section 151 of the Code of Civil Procedure filed by the defendant number 2 stroke respondent, comma, the learned trial judge has passed an order of stay of operation of a notice dated September 7, 2024, issued by the Secretary, comma, Shahu Samaj Trust, West Bengal, till disposal of the suit. For sub next parallel, counsel for the plaintiff stroke appellants argues that the said relief was entirely beyond the subject matter of the suit, and as such, comma, no injunction could have been granted under Order 39, Rule 1 of the Code of Civil Procedure. For some next para, the entire plaint case, comma, it is argued, comma, revolves around a trust, comma, by the name of Shahu Samaj Trust, West Bengal, comma, which was formed in the year 1981. For sub next para, there is no mention in the plaint of the suit as to there being any other trust of the year 2018. For sub next para, the premise of the plaint case is that the defendant number 2, comma, who was at one point of time chairman of the trust, comma, had resigned from the chairmanship, even otherwise, comma, his tenure having been over long back, comma, the defendant number 2 stroke respondent does not have and is no longer a portfolio holder in the said trust of 1981. For sub next para, learned counsel points out to the affidavit in opposition of the respondent, defendant number 2 stroke respondent, comma, in paragraph number 10 of which it has been admitted that though the said respondent has not been elected in any post of office bearers, comma, he was and is continuing as an ordinary trustee of the said trust. Full stop. Next para. Thus, comma, it is argued that the defendant number 2 stroke respondent does not have any locus standi to object to a validly convened meeting of the trust. Full stop. Next para. Learned counsel takes the court through the prayers, the relief sought in the plaint, and argues that the same is entirely focused around the validity of the election by dint of which the present plaintiff stroke appellants have become the office bearers of the trust, that is Shahu Samaj Trust West Bengal. For sub next para, the ancillary reliefs in the suit, comma, it is submitted, comma, pertain to a bank account, comma, the operation of which by the plaintiff stroke appellants is being sought to be interdicted by the defendant stroke respondent number 2 unlawfully, comma, in view of the said respondent having no locus standi to do the same. For sub next para, hence, comma, it is argued that the stay granted by the impugned order is entirely beyond the scope of the suit itself, and the pleading of the purported 2018 trust finds place for the first time in the application under section 151 of the code filed by the defendant stroke respondent number 2, and is not the subject matter of the suit at all. Which of next para, secondly, comma, it is further argued by learned counsel for the appellant that the notice, comma, the operation of which has been stayed, comma, was dated September 7, 2024, and merely seeks to convene an annual general meeting of the trust, comma, inter alia to consider and pass the accounts of the trust, comma, to elect stroke select from among the trustees a new trust body formation in terms of the deed of trust of September 25, 1981, comma, to elect from amongst the trustees portfolio holders stroke office bearers, and also to take a decision as to whether the entire building of the trust is to be demolished and the reconstruction of the same is to be undertaken. Which of thus, comma, it is submitted that it is premature at this stage to come to the conclusion that any final decision has been taken regarding such demolition. Which of the application of the respondent number 2, from which the present impugned order emanates, pertained to the alleged apprehension that the demolition would frustrate the rights of the defendant stroke respondent number 2 in the suit. Puts up, however, comma, since the subject matter of the challenge in the application under section 151 was the notice dated September 7, 2024, and demolition was merely one of the agenda therein, comma, in view of no infraction of the provisions of the trust deed having been made out in issuance of the said notice, comma, the learned trial judge, comma, it is submitted, comma, erred in law and in fact in staying the operation of the same. Full stop. Next para, learned counsel appearing for the defendant stroke respondent number 2, comma, the primary contesting respondent, comma, submits that by way of the plaint, comma, the plaintiff stroke appellants seek to confuse the court between the trust of 1981, comma, pertaining to the Shahu Samaj Trust, comma, West Bengal, and that of 2018, comma, which pertains to the Shahu Samaj Trust within bracket simpliciter, bracket close, full stop. Next para, it is argued that whereas the plaintiff stroke appellants may be trustees and office bearers of the 2018 trust, the property sought to be demolished does not belong to the said trust but to the 1981 trust. For the next para, learned counsel appearing for the respondent of 2 argues that the resignation purportedly tendered by the respondent number 2 was in respect of the 2018 trust and not the 1981 trust. For next para, it is submitted that unless the court conclusively decides as to the dispute regarding the respective right of the parties to the office of the to the offices of the 2 trusts, if the building is demolished, the defendant number 2, defendant stroke respondent number 2 shall, as well as the trust, shall suffer irreparable injury. Next para. Upon a perusal of the plaint, we find that the same revolves around the 1981 trust alone, and there is no mention of any trust of 2018. Next para, going by the plaint, we find that the scope of the suit is whether the plaintiff stroke appellants are validly elected office bearers of the said trust of 1981. Next para, as a consequential relief, certain injunctions have been sought in respect of the bank account operated by the said trust. Next para, from the 4 corners of the plaint, we do not find any mention of any Sahu Samaj Trust, but only of the Sahu Samaj Trust West Bengal, which was formed in the year 1981. Next para, thus, the application filed by the defendant stroke respondent number 2 under section 151 of the code seeks to expand the scope of the suit without making a separate counterclaim and stroke or filing a different suit. Within the contemplation of the suit, as framed, there is little or no scope of construing the building in question to be the subject matter of the suit. Next para. Secondly, we find the apprehension of the respondent number 2 to be premature, since there has since no decision to demolish the building in question has been taken till date. Next para, we find from the notice dated September 7, 2024 that demolition of the concerned building was only one of the agenda therein. By the said notice, the accounts of the trust for a particular period were to be considered and passed, new trust body was to be formed by way of election stroke selection, and portfolio holders were to be selected from the said new trust body. Next para, by the impugned order, the entire notice has been stayed, thereby freezing the valid and regular functioning of the trust itself. Next para, insofar as demolition of demolition of the building in question is concerned, in terms of the notice, it is only subject to a resolution stroke decision being taken in the meeting to be convened by dint of the notice. Thus, it would be premature to jump to the conclusion at this stage that such a decision will definitely be taken. Next para, even otherwise, it has been submitted by the appellants that the defendant stroke respondent number 2 has been co-opted as a trustee and is at liberty to participate in the meeting to be convened pursuant to the September 7, 2024 notice. But the date is already over.
Yes, my lord, possibly we have to give another one. But we will give him, my lord, notice. If
Next para, even otherwise, we find that the scope of the impugned order has already spent itself, in view of the appointed date of the annual general meeting as notified by the impugned notice has already passed. Full stop. Next para. Thus, comma, in any event, comma, little remains to be decided in the present appeal. Full stop. Next para. Be that as it may, comma, in view of the aforesaid observations, comma, we find that, comma, in principle, comma, there was no substance in the application under section 151 of the Code of Civil Procedure, and the impugned order could not be sustained. Full stop. Next para. Be that as it may, comma, in view of the present appeal being rendered infructuous, comma, FMA 286 of 2025 is disposed of with the observation that in the event a fresh notice is issued by the plaintiff stroke appellants in accordance with the provisions of the trust deed pertaining to the Sahu Samaj Trust West Bengal, comma, and subject to the plaintiff stroke appellants having authority to do so otherwise, comma, such notice shall also be served on the defendant stroke respondent number 2, and the respondent number 2 shall be granted an opportunity to participate in the said meeting, comma, to be convened in terms of such future notice. Full stop. Next para. We further observe that all the above observations and the findings of the impugned order are tentative in nature, comma, to be tentative in nature, comma, not to be binding, not to be treated as binding at any further stage of the suit or interlocutory applications. Full stop. Can such and such is accordingly disposed of. Can 2 of 2024 is also disposed of accordingly. No rest to costs.
Very grateful, my lord.
Thank you.
It was a pleasure appearing before the bench.
That's meant for my learned brother. Yes.
My lord, I am appearing on behalf of the respondent number 1, my lord.
Yes.
My lord, I am for the appellant.
Yes,
I understand, my lord, they are filing their opposition today. So I am praying for 3 weeks' time to file my reply.
No copy has been given to you?
No, copy has been given to me.
When did you get the copy, Mr. Mishra?
3rd of August. That was out of time as per your direction.
Why 3 weeks? We granted you already.
My lord, I will be going
7 days time.
I will be going out of station for some medical checkup. That's why, my lord.
Are you enjoying an interim order?
Yes, my lord. Yes.
Then Mr. you can't grant you so much time.
No, so kindly.
You are not using any affidavit in opposition.
My lord, I have already filed.
Already
my
filed.
lord.
So you have filed the reply to their respondent number 1's affidavit.
Yeah, my lord. 2 is filing today. I will.
So what
I
about
filed
the reply to
Yes,
their
yes.
their opposition? You have filed a reply
Yes,
already.
yes.
My lord.
Today I'm filing affidavit in opposition.
I give you a fortnight's time, Mr. Fortnight. The affidavit in opposition filed
My
today
lord.
by the respondent number 2.
My lord, may I apprise one thing, my lord?
Yes.
In the premises where they are enjoying the interim order, my lord, there I have a business, my lord. I am doing that business. If my lord pleases, my lord, kindly vacate that part only, that so that I can enter and do my business.
That is a residential building, my lord.
What order have you passed?
The interim order has been passed upon the building, my lord. And so
what is the date of that order?
They are doing business. That is a residential building.
we were rented over there.
They
We were rented a long time
they
back.
don't have even fire license.
You have been restrained from selling, transferring, alienating,
Yes.
My
and
lord,
creating
my lord.
third-party interest only, nothing else. Don't do that.
My lord,
No, there is no bar to business in our order.
my lord, my lord, my lord.
How is
Grateful,
it
my lord.
affected?
Why gratefully? You should have seen the order first before submitting this.
My lord, I'm just apprising, my lord. Just taking.
No, but so 23rd February 2026 order is on the website, and paragraph 8 of that only restrains you from.
My lord, they were saying that we can't do business also. For that reason,
No, that's not in our order.
That is residential.
will be
building.
affecting my life.
File today be kept on record. Full stop. On the prayer of learned counsel for the appellant, comma, the time for filing reply thereto is extended for a fortnight from date. Full stop. Next para. The matter be listed next in the monthly list of September 2026 under the same.
Highly grateful, my lord.
Thank you. Next.
So I appear on behalf of the appellant.
Yes.
Pursuant to the last direction passed by your lords, we have served notice along with the server copy of the order passed by your lordship on the
They have
learned
not
advocate for
received.
the caveator. Yes, yes.
Respondent,
He is
the
appearing.
difficulty is I could not prepare my objection, Lordship, as
Why?
Lordship, the opposite party is not present in Kolkata, Lordship, right now.
No, it was served long back.
Yes, Lordship, on the last occasion,
20th of July it was served.
it was served on 29th of July, the order was passed, Lordship.
No. 27th order was passed. Immediately it was uploaded in the server. I have notified to
The
the
next day they have served, 28th.
Yes, Lordship, the Mr. Arijit Banerjee, the opposite party hearing, is.
That's not a good ground.
Lordship, I
So he has
could not
not been, so you could have prayed for an extension then. He is not
There
there
is a
from when?
stay, Lord. From 19th of July, he is out
When
of
is he due
Kolkata,
to come
Lordship.
back? We cannot give you indefinite time.
End of the August, Lordship. Kindly
You are enjoying an interim order.
So in interim order with regard to status code to be maintained in respect of the properties. My
2 weeks.
probate application was rejected on the ground of non-production of the original. The original was
I think the
produced.
time will, what can be done? On the prayer of the respondent, the time for filing opposition is extended till August 31, 2026. Reply thereto, if any, shall be filed by September 7, 2026. The application shall be listed for hearing next on September 9, 2026.
So kindly indicate the interim order.
It was there already till this.
So it's till disposal.
You have forgotten your own order. Good. Give your appearance, ma'am. Appearance.
Yes.
Yes.
But matrimonial suit dismissed expert. But cruelty ground well established, but due to non-corroboration of any documentary evidence.
You're asking for setting aside of the order at the interim stage. That is the interim.
And
so we'll pass necessary direction for service of notice and all these things. Very well. Since the present appeal arises out of the dismissal of a divorce suit filed by the appellant, there is no scope for grant of stay. Full stop accordingly, can 1 of 2026 is disposed of by directing the appellant to put in postal requisites, Talabana and written up notice form for effecting service of notice on the respondent within a week from date, full stop. The trial court record shall be brought by special messenger, at the cost of the appellant, also to be deposited within a week. Full stop, the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Lordship.
I'm great.
No, this is not mentioned.
Lordship,
হলো না? তাহলে আর কি করা যাচ্ছে? যেটা এমনি লিস্ট কল করুন।
My lord, beg to appear on behalf of the appellant wife, my lord.
Right.
I was a plaintiff, my lord. Suit for divorce was dismissed. My lord,
Divorce was granted.
Dismissed,
Dismissed,
my
right.
lord. My lord,
Will
I
pass.
for you use an order, my lord.
There is no scope of stay, so with
No,
the
my lord. there's no
paper
scope.
books and all.
My lord.
The present appeal arises out of the dismissal of a divorce suit filed by the appellant wife. Full stop. As such, comma, there is no scope of any stay. Stop. Can 1 of 2026 is disposed of by directing the appellant to put in postal costs and requisites for service of notice of the appeal on the respondent within a week from date. The trial court record shall be brought by special messenger at the cost of the appellant, comma, also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. A liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. No arrest to cost.
I'm extremely grateful.
Yes. Yes, Mr. Mukherjee. Which respondent, Mr. Mukherjee? There are two sets.
Your Lordship, respondent IPF for the appeal, Your Lordship.
4 and 6 to 9.
No, you must be 2 to 4 and the rest.
Sorry, 2 to 4 and 6 to 9. But my friends on the other side has filed an application
For substitution, Your Lordship.
Oh,
On the last occasion, on
that's not
They
a
have indicated that the entire substitution matter has been otherwise delayed in view of the fact that we have been not intimating them. But
Your Lordship, the
they are
substitution application is appearing before us.
yes, Your Lordship, can 3.
and 3. Kaka Bhaipo is not knowing each other and what to be.
Mama Bhagni, you could still understand. You could still understand that there may be an enmity.
But they didn't know that he is dead.
Yeah, allow me to say.
In fact, before the trial court, my lord, the order was passed in respect of the substitution. That is known to them. That was sometime in June 26.
So this is against what sort of a decree?
This is the
Preliminary degree partition.
Partition.
My lord,
In the trial court, substitution has been effected.
yes.
Then
No,
No, Your Lordship, Senior Aniruddha Chatterjee is in this matter. I am praying for a short passover. And in the lower court, there is no such order regarding this substitution application because they haven't served any copy upon us. Because if you consider the last order in this court, there it was mentioned.
I don't want to go into a dispute.
So I have to let no learned court.
Proceeding, I don't have any opposition. Yeah, আপনারা চাই আপনাদের নিতে পারেন. You can take a copy.
you are the defendant there, or
plaintiff, Your Lordship.
respondent number 5 is the defendant number 2 there.
Defendant number 5.
Opinion number 5.
2
2
days.
there. This is regarding that.
Oh, defendant number 2 there. I'm sorry. Kindly see the order of 17th of June 26.
Yes.
It has
Yes,
already been done. What happened is that a preliminary decree was passed in this particular matter.
But हो गया
Keeping in mind
substitution.
the order passed by my Lord Justice Shampa Sarkar in respect of this issue. My Lord Justice Shampa Sarkar held that the shares in respect of the parties are all admitted. In view of the admission of both the sides admitting that the shares are admitted, there is no reason to keep the matter pending for a final preliminary decree. And for that, the preliminary decree was passed by the trial court, keeping in mind the order of the Honorable High Court. Now they have come up on that order was also passed on consent. They have said that within the meaning of section 96 subsection 3, they can otherwise come up in against an order. I do not oppose that situation that they actually can come, but practically I respectfully submit. Even the plaintiff have said that I have got 1/4 share. Can I now say that I have got 1/10 share?
There was a substitution in the trial court.
I was.
You are the plaintiff, you must have done it.
Not the plaintiff, the defendants, partition should anybody, But I was thinking on different lines. But this litigation belongs to, my lord, a very prestigious judicial family. Yeah, if it could be settled, my lord, without, my lord, getting into the litigation part, I think that will be the best.
Allowing the substitution, Mr. Mukherjee, would you like to go to mediation, or between yourselves also you can want?
Mediation has failed.
You know, before anybody from your lordship's court, looks to the name, my lord, your lordship would realize it's.
My Lord Justice Anil Shin, why aren't you saying the name? It's not no problem.
It's not, might not be. My lord, we have grown up, my lord, as two. But knowing
I've
that.
not yet grown up.
No, your lordship is always young, my lord. That is perfect.
That goes to show
But
by the
we-
face.
So after this, we have to allow this application. So you are allowing this application. What do you want? What is the course of action you suggest?
If I can sit with my learned senior friend, my lord.
No difficulty. Then we are allowing the substitution. There are other applications also.
That was stay application.
That is pending.
Yes, and a 4127.
So what do we do? Tell us.
And let me sit with my.
We can
learned
allow
senior-
this substitution so that the appeal,
Substitution may be allowed.
and then keep the application a week hence so that you can.
Yes, but I'll sit with him. I'll sit with him and I'll try and, my lord, if something can be worked out.
How do you resolve the? You did not take out the substitution. The present application has been filed for substitution of the heirs and legal representatives of the deceased respondent number 5, comma, who was the defendant number 2 in the trial court. First of next para, learned senior counsel appearing for the respondent numbers 2 to 4 and 6 to 9 submits that, comma, in the trial court, comma, a substitution of the said heirs was already effected, has already been effected. Video order dated June 17, 2026, footstop. As such, comma, it ought to be within the knowledge of the appellant, comma, who was the plaintiff in the trial court, comma, regarding the same. Footstop. Moreover, comma, it is submitted that the appellant and the deceased are related as nephew and uncle, respectively, and as such, comma, there is no reason as to why the appellant was not aware of the demise.
Niece and uncle.
Niece, sorry. No. Appellant is a male.
Appellant female.
Oh, sorry. Niece and. But a nephew to niece. Next. The learned counsel appearing for the respondent number 1 points out that the submits that the appellant had knowledge of the demise during pendency of the suit. Full of next para. However, comma, learned senior counsel appearing for the appellant points out that it is not the plaintiff stroke appellant but the defendants who had taken out the substitution application in the trial court. Full stop. Next para. As such, comma, no direct knowledge can be attributed to the appellants. Full stop. Next para. Be that as it may, comma, upon hearing learned counsel for the parties, comma, particularly taking into consideration the fact that the cause of action in a partition suit is a continuing cause of action and an application for substitution is in the nature of an addition of party application, comma, we are inclined to allow the substitution application upon condonation of the delay and setting aside abatement. Full of next para. Accordingly, can 3 of 2026 is allowed, comma, thereby directing the heirs and legal representatives of the deceased respondent number 5 to be substituted as respondents in the appeal, appeal, comma, after setting aside abatement and on condonation of delay in filing the present application. The necessary rectifications in the memorandum of appeal and the other applications shall be carried out by the learned advocate on record for the appellants during the course of the day. You will carry out the appellants. Next. No orders to cost. Next para. At this juncture, comma, learned senior counsel appearing for the parties point out that there may be that the avenue of amicable settlement may be explored between the parties. Next para. Accordingly, let the matter stand adjourned till. Should we adjourn for 2 weeks? Or?
2 weeks, well, because I will be a
next
little
week,
bit.
this week from Thursday, I won't be in town.
We'll put it on then 24th. We are keeping it 24th Monday week on August 24th, 2026. When the pending applications shall be listed under the same heading.
Great.
First up, in the meantime, comma, the parties will be at liberty to attempt settlement, mutual settlement between themselves.
My appeal. There is section 5 application appearing after service.
The Church of North India. My learned brother used to appear for the Church of North India regularly. They will release the matter. The second day is not a good day for taking up the in view of one of us, bracket having appeared for the for one of the parties while at the bar in several matters, comma, for the sake of judicial propriety, comma, the matter is released. The matter is released on personal ground with liberty to the parties to seek an assignment before a different bench from the Honorable the Acting Chief Justice. Sorry, Mr. Dasgupta, but should not. Yes, Mr. Mukherjee.
Lordship, this present applicants are the plaintiff in a partition, suit for partition and declaration of title. Now, Lordship, all these appellants are the sisters.
Yes.
And respondent number
Appeal
1,
was
2.
admitted, Mr. Mukherjee. Appeal was admitted.
No, Lordship, this is the against the administrative injunction.
This appeal was admitted.
Yes, yes. There is a direction for affidavit. Everybody already exchanged.
So, a suit for?
Suit for partition and declaration.
They filed the suit.
We have filed a suit. Our administrative injunction has been refused.
On what ground?
Lordship, two grounds. One is, Lordship, we could not annex any photographs, we also could not produce any video before the learned judge.
To show what?
To, Lordship, show that this property, civil property is in danger. Now, Lordship, this first ground, and second ground is, Lordship, we are the sisters. My brothers, Lordship, transferred our share to pro forma defendant. Now, we have prayed for injunction who are now admittedly now raising construction, Lordship, against the pro forma defendant. Now, against the pro forma defendant, Lordship, this administrative injunction has been refused. Lordship, kindly come to the impugn order.
See the impugn order, yes. But the second ground we could not understand.
Lordship, kindly come the impugn order. I have kindly come to the memo of appeal.
Yes, yes.
Order dated 11th November 2025.
Mr. Ghosh, you are for the purchasers.
We are for the purchase. Well, we have been attached pro forma.
In this?
Pro forma
there. But here?
Same.
They are the respondent. No?
Pro forma.
Pro forma. Anyway, so, but in the appeal, you are seeking relief against them only. Anyway.
Kindly come to paragraph 7. Memo of appeal, Lordship, kindly come. The certified copy, order dated 11 November 2025.
What injunction did you ask for?
Lordship,
change of nature character or what?
Now, Lordship, they have already started construction in our land. So, Lordship, we have prayed for administrative injunction against the
brothers have sold the entire property to them.
Entire property.
Your share also.
My share. This is admitted fact, and they have also admitted in their opposition also.
Proforma defendant করলে কি কারণ proforma defendant law recognize করে না যে proforma করছে যেটা দেবেন না পরের কথা
Lordship, this is not in dispute that Charubala Dasi and Navakumar Kole.
Yes.
Lordship, this is not in dispute that Charubala Dasi and Navakumar Kole, Lordship, predecessor interest was the owner of 21.5 decimal of land. Lordship, our father Nitai Chandra Kole, since deceased, was the original of the entire land. Now, our mother.
What is this? This should be treated as pro forma
Lord, that
defendant.
is immaterial, my lord. But whether or not your lordship kindly consider
They
the
should
merit of the case.
produce a video and photographs. Averment on oath adding
No,
to
no.
stage, Mr. Ghosh.
Lord, your lordship, they have not annexed the plaint or injunction application with the stay application, with this application before your lordship. Lord, your lordship kindly see the plaint. When they have come, when my lord, the transfer took place, when the construction done, and it has been already completed. And Lord, the property in question, which is disputed, only a portion, small portion has been taken. Other portion is outside the construction.
Let us see the plaint, what they have stated.
Lord, your lordship,
You have disclosed that in your opposition.
yes.
Lordship, kindly come.
Look,
That is
certified copy, direct minus kora.
plaint at page
Lord, page
56.
56.
They state that you have started to dig the earth and all. From the plaint is not evident. We have to go by the plaint and injunction application at the identity stage.
Yes. Lord, kindly see that when they came to learn about the transfer, and Lord, they have admitted that during the conversion of the land from this Kolabagan and other Sali to the Bastu or Karkhana, Lord, they made objection. Thereafter, it was conversion was made. They didn't contest. Lord, they admittedly had knowledge of the transfer. Your lordship will come to their paragraph in the plaint. Lord, date of their knowledge and similar, they have admitted. Lord, your lordship will come to page 65, paragraph 15. And Lord, date of filing of the suit, thereafter filing of the date of filing of the injunction application. And
21st of January, they came to know that defendant sold out the suit land.
Yes.
That
Came
is
to
not
learn-
equivalent to
Came to learn on Ato. The
The deed was executed
deed
on
is 24.
6th
They say that they came to know of the sale on this date.
This date.
Does not speak about construction being started.
No,
from
no,
that.
kindly this. This has been done. They came to learn about this, and thereafter, my lord, before that, there was mutation. Thereafter, my lord, this conversion.
That is not equivalent to construction, Mr. Ghosh.
Yes,
If
Lord.
you construct and change, because their case is that brothers have sold also their shares to you.
Lord,
See, if you construct over the whole
Lord, they
property,
have
what
alleged.
remains?
What is this document that they have inherited the property? Only my lord Panchayat certificate. Nothing. No birth certificate, no school certificate, nothing else. That is another thing. Lord,
At interim stage, Mr. Ghosh.
Lord, your lordship kindly see one thing. Your lordship kindly, as a whole, our project cannot be stayed. Your lordship kindly see, I have annexed the project plan and
You
other.
cannot look into your documents at the ad interim stage, Mr.
Lord,
At the ad interim stage, you can file a written objection, have it chased out.
Lord, there is nothing. They have not made out any case. Lord, rather, Lord, your lordship will find that they had knowledge and they did not take any steps for filing injunction. That apart, Lord, suit has been filed. Lord, in the month of suit has been filed on 24th September 2025. Thereafter, an injunction application was filed on 11th November 2025. And Lord, we kindly see that here they have not annexed, though the court directed to serve copy of the plaint, they have not served. We took certified copy and did not approach before this honorable court to file.
Because the ad interim was refused, therefore 39(2)(a) does not apply.
No.
3(a) does not apply.
Yes, it was refused. But Lord, in spite of our appearance, when we sought for copy of the plaint, they declined.
They did not give you.
No, Lord, certified copy we have taken. And Lord, here also, they have not annexed the plaint. And Lord, kindly see, they have stated in their plaint itself, Lord, once take Lord page 40 of our affidavit in opposition. That is the project plan. Lord, your lordship may or may not consider it. Lord, these are the DAG numbers. Lord, 3143, 3144, 3145.
কোনটা কোনটা 3145
Lord, kindly come to page 40.
Yes, 40.
Lord, this is the structure and photograph of the structure is not
But
the.
it is documents in the trial court, Mr. Ghosh.
Lord, kindly see these are the.
These were not available at the stage when the injunction was refused. Court's grounds
These are
are
there.
both
Lord,
grounds
kindly
are-
see.
How could it be there?
These are the structure, Lord, kindly see. It is already been done.
How could it be there? You are at the ad interim stage, expert ad interim stage.
Lord, structure is done, only shade is, your lordship kindly allow us without claiming any equity, allow us to put the shade on the structure. Structure is already there. And Lord, we have kept that particular land aside.
Cannot construct on the whole property.
I'm not, Lord, kindly see. We have admitted, kindly record our submission that we have not constructed and this will appear from this. Lord, kindly see the DUG numbers I have given here, 3143, 31444, 3145 and 3148. It's outside.
They have only narrated that there are threats and digging and attempts to raise a boundary wall.
That is
That is
already
there.
done. No wonder it is construction is already there.
Put in a written objection within a week, Mr. Ghosh. We'll direct the trial court to do it within a.
But so far, my lord, the entire project cannot be stalled. Your lordship.
Yes, yes, it can definitely be stalled for 5 or 6 weeks. No difficulty.
No, kindly see, your lordship, law is settled. They have not come in time, first point. Second point, but the entire project will have purchased 300 bighas of land. 2 construction has been let out. Lord, your lordship kindly allow us to put our shed and Lord, subject to Lord, this without our undertaking that we shall not claim any equity. Let it be done. But we have not, we have specifically on oath said that we have not covered their area. But kindly see. But that apart, your lordship kindly consider 2 brothers, even if accepted that they are co-sharers, that to the extent of they are 5/6 share, 5/8 share. Lord, we are 2/8. Then Lord 18 decimals we are entitled to. The 18 decimal has not been covered. It may cover Lord 18 decimal only. Other portion has been left open. Your lordship kindly make some comment on that on that aspect of the matter, that it should be kept apart and other portion may be covered. Construction is already there. Lord, this is the photograph.
You have
this is go down.
According to them, you have 3/8.
Lord,
according to them, you have 3/8.
3/8.
2/8. 2/8.
No, another sister is with us. Huh?
With you means?
2 brothers.
2/8.
Lord, 2 brothers.
So 2/8.
2/8. 9, 9, 18. 11, 71 decimals.
So kindly see the deed.
Lord,
Also,
other
the 2 brothers has affirmed that they are the sole owners of the entire
Where is the
property.
deed?
Kindly come to the deed. Page 58 of my stay application.
It is still there.
Kindly come page 61. Absolute and recorded owners. First line. Page 61, first 2 lines.
And that is there.
This covers the entire suit property.
Entire suit property.
Lord, kindly see this, that we have searched before purchasing. It is in the name of Nitai. Thereafter, it was mutated in the name of 2 brothers. We had no knowledge about the share of the sisters, existence of sisters. Lord, that apart, kindly see, Lord, page 13 of their affidavit in reply. They were invited. They made an objection regarding Lord conversion of the land. Lord, the authority concerned issued a notice, but they didn't appear. Thereafter, conversion has been made. Your lordship, kindly see page 13 of their affidavit in reply.
Yes, Mr. Ghosh, you are granting injunction. The present appeal has been preferred.
Lordship, kindly, Lord, consider this aspect of the matter.
We'll
Your lordship,
consider. Yes.
without claiming any equity, Lord, your lordship, Lord, cover the shade only.
Mr. Ghosh will not.
Lord, shade.
The present appeal has been preferred against an order whereby ad interim injunction has been refused
Prima facie case
in
is
a
not
partition suit filed by the plaintiff stroke appellants, comma, who claim to be 5/8 co-share, 5/8 who claim to be owners to the extent of 5/8 share in the suit property, comma, being the sisters of the principal respondents. For sub next para, learned counsel for the appellants argues that the learned trial judge refused to grant ad interim injunction on twofold grounds, comma, first, that no photographs or videos were produced to show that construction was going on, and secondly, comma, that the pro forma respondents herein, comma, who are subsequent purchasers from the principal respondents, comma, against whom the main relief was sought in the injunction application, comma, were arrayed as pro forma defendants, comma, instead of principal defendants. For sub next para, accordingly, it was observed by the learned trial judge that if plaintiffs so intend and are advised, comma, may seek transposition stroke implement under Order 1, Rule 10 within bracket 2 of the Code of Civil Procedure with regard to the pro forma respondents, comma, by bringing them to the category of principal defendants instead of pro forma defendants. So the next para, learned counsel places reliance on the transfer deeds executed by the principal defendants, principal respondents, comma, the two brothers of the present appellants, comma, in favor of the pro forma respondents, stroke third parties to the family. For sub next para, from the said documents, comma, it is evident that the vendors, stroke principal respondents gave themselves out to be sole, comma, absolute and recorded owners of the entire suit property, comma, by suppressing the 5/8 share of the plaintiff stroke appellants. For sub next para, it is argued that in view of both the premises of the impugned order being erroneous and the learned trial judge having failed to advert to the aforesaid considerations, comma, the impugned order ought to be set aside. For sub next para, learned senior counsel appearing for the pro forma respondents argues, comma, by placing reliance on the annexures to the affidavit in opposition filed by the pro forma respondents in this court, comma, that a huge project is coming up at the behest of the pro forma respondents on the suit property. Since the primary structures have already been erected, comma, it is submitted that the pro forma respondents will suffer injury and loss and substantial loss in the event the injunction is granted. It is submitted that thus, comma, the balance of convenience and inconvenience is against the grant of injunction. Next para, learned senior counsel further argues that even if it is assumed that the pro forma respondents acquired the brothers, the shares of the principal respondent numbers 1 and 2, stroke brothers of the appellants to the extent of 2/8 share in the property, comma, which comes to about 18 decimals of land, comma, the construction which is coming up on the suit property at the behest of the pro forma respondents is being built within the said area. Thus, comma, in any event, comma, the shares of the vendors of the pro forma respondents has not been exceeded in making the construction. Next para, learned senior counsel next argues that even as per the plaintiff averments, comma, it will be evident that the plaintiffs stroke appellants had knowledge of the conversion of the property and the obtaining of sanction plans by the pro forma respondents since long back. However, comma, the appellants chose to keep silent and permitted the construction to commence substantially, comma, thereafter coming to court and seeking injunction. It is argued that the law is well settled that in such circumstances, comma, no premium should be given to such delayed application for injunction. Next para, lastly, comma, learned senior counsel contends that the appellants have failed to prove foundational documents to show that they are sisters of the respondent numbers 1 and 2 and, comma, as such, comma, have title in the subject property. Next para, upon hearing learned counsel, comma, we propose to decide the matter, decide the appeal along with the application, comma, in view of the brief point involved, comma, as follows. A cardinal principle of adjudication by the court at the ex parte ad interim stage of injunction is that the averments made in the plaint and the temporary injunction application are to be taken as sacrosanct for the limited purpose of consideration of grant of ex parte order or refusal thereof. At this stage, comma, the court cannot look into the documents sought to be relied on by the respondents or the pro forma respondents. Next para, since the documents now relied on by the pro forma respondents were not before the learned trial judge at the time of passing of the impugned order, comma, it is beyond the jurisdiction of this court, comma, on a composite reading of Order 39 Rules 1 and 2, comma, read with the provisions of Order 43, comma, to go beyond the pleadings and look into the documents sought to be produced by the pro forma respondents. Full stop. Next para. The present appeal is cylindrical in nature insofar as judicial hierarchy is concerned, pyramidal in nature insofar as judicial hierarchy is concerned, and the appellate court cannot look into documents which were not there before the trial court. Full stop. Secondly, comma, from the averments made in the plaint, comma, we only find that allegations have been made that the pro forma respondents are digging and preparing to make constructions on the subject property. Full stop. It is not disclosed in the plaint as to whether the plaintiffs were aware of the construction since long back and stroke or that the construction has been raised up to a substantial level. Full stop. Next para. Thus, comma, on a plain reading of the plaint, comma, we find a sufficiently strong prima facie case having been made out by the plaintiff stroke appellants. Full stop. At this stage, comma, the averments on oath made in the temporary injunction application and the plaint are to be looked into, comma, from which we find that by the transfer deeds in favor of the pro forma respondents, comma, the principal respondents transferred the entire suit property, comma, thereby prima facie suppressing the 5/8 share, that is the majority share of the plaintiff stroke appellants. Full stop. Next para. Thus, comma, at this juncture, comma, if the pro forma respondents are permitted to raise construction, comma, the suit may be rendered ultimately infructuous. Full stop. Next para. However, comma, we make it clear that the above observations are tentative, comma, based only on the averments made in the plaint and the injunction application, and it will be open to the respondents and the pro forma respondents to file their respective written objections to the temporary injunction application in the trial court. Full stop. As and when the said objection is filed, comma, it will be open to the learned trial judge to decide the temporary injunction application on merits and in accordance with law, comma, by treating the above observations and those passed in the impugned order to be tentative in nature. Full stop. Next para. Insofar as the grounds resorted to by the learned trial judge in passing the ad interim passing the impugned order, comma, we do not find substance in either of those. Full stop. Next para. At the ex parte ad interim stage, comma, as indicated above, comma, the court has to proceed on averments made on oath in the plaint and the temporary injunction application. Full stop. At such stage, comma, it is only the apprehension of the plaintiffs which is to be looked into, comma, which is quite clear from the averments of the plaint and the temporary injunction application, comma, even in the absence of photographs, comma, side video, comma, etc. Full stop. Next para. Insofar as arraignment, ARRAIGN, meant of the pro forma respondents as pro forma defendants in the suit, comma, despite the main relief having been sought against them, comma, the law does not distinguish between a defendant, double inverted, and a double inverted with a pro forma defendant. Full stop. It is only a matter of convenience that a practice has developed to implead proper parties as pro forma parties, whereas the principal parties are impleaded as principal plaintiffs stroke defendants. Full stop. Next para. However, comma, in law, comma, there is no distinction between the two. Full stop. Since it is evident from the plaint and the temporary injunction application as to against whom the principal relief has been sought, comma, there could not the mere arraignment of the pro forma respondents in such capacity could not have been a factor for refusing ad interim injunction to the appellants. Full stop. Accordingly, FMAT 92 of 2026 is allowed on contest, comma, thereby setting aside the impugned order, comma, bearing order number 2 dated November 11, 2025, passed by the learned civil judge, senior division at Chandannagar district, Hooghly, in title suit number 186 of 2025, and restraining the pro forma respondents and or their main agents by an order of injunction from changing the nature and character of the suit property till disposal of the temporary injunction application in the trial court. Full stop. In the event the respondents stroke and pro forma respondents file their respondents দরকার নেই. In the event the pro forma respondents file their written objection to the temporary injunction application within a fortnight from date, comma, it is expected that the learned trial judge shall dispose of the injunction application itself as expeditiously thereafter as possible, comma, preferably within 4 weeks from the date of filing of such written objection, comma, without being prejudiced in any manner by any of the observations made herein above. Can 1 of 2020, 2 of 2026 is accordingly disposed of as well. No orders to cost. Urgency. Thank you. Next. Can 1 was যা যা can আছে সব accordingly. 1টা কি ছিল?
Get outside with my lord's hand.
Yes. Next. Review কি শুরু করতে হবে? ওটা দেখুন। ও আচ্ছা। এটা একটা ঠিক আছে। কিন্তু নিচের মধ্যে দেখতে।
Item number 17 to 19. My lord, in item number 17, I am for the appellant, my lord. I am being led by senior advocate Probal Kumar Mukherjee. He is in another court and I'm praying for a short passover, my lord.
It's not a good ground. You start the matter.
My lord.
If I may come to her.
You are also in another court. Yes.
The appeal needs to be heard. So if because
Then Mr. Mukherjee has to.
that can be.
So we are make it not today then.
Lordship, hears out the appeal, my lord, whenever your lordship pleases, because the affidavit, ad interim order, my lord, the affidavits, everything has been exchanged.
Not ad interim order.
Hey, final order, I'm sorry.
Injunction application finally disposed of.
Yes, so everything is there. The
Injunction was granted.
Injunction initially was rejected.
Oh, forget initially.
Yes,
but
initially
it was
granted.
So you'll have to hear the appeal then. Very well. An adjournment, an accommodation is sought on the ground of learned senior counsel for the appellants. Full At this juncture, learned senior counsel appearing for the respondent was 1 and 2 points out that since all the pleadings are before this court, comma, the appeal may be taken up for hearing along with the application. Accordingly, let the matter be listed, let the appeal be listed for hearing along with the application on August 13, 2026, Thursday.
17, 18 and 19 are together.
আচ্ছা appeals plural হয়ে
Item number 20.
Just give us a second, brother, because
for what? Next matter? So give your names. You also give your name.
yes, sir. Mr. Mukherjee's name also.
No. Probaler নাম দেবেন না. Yes, Mr. Bhattacharya. Yes.
My lord, on the last occasion, my lord had allowed the restoration application, my lord.
Sorry. Now order for turn.
Now order for turn.
Eviction. Both courts.
No, my lord. This is, my lord, for cancellation of the deed. My lord, on a day 7th of August.
But tell us you are the plaintiff or defendant?
I'm the plaintiff.
Cancellation of a deed.
Deed.
Executed by you?
No. By the mother. By the mother.
Cancellation?
Yes, cancellation. Not. It should have been not binding fraud.
Achha, mother executed. Mother during her lifetime did not challenge.
Mother did not challenge. Now, my lord, the my lord, contest is between two brothers. Now, my lord, the same.
Lilavati Devi. Number 1.
Lilavati Devi is, my lord, the widow of the
one of the brothers.
One of the brothers.
So the other brothers said.
Now, my lord, what happened? The same, my lord, property which was, my lord, gifted to us in 2009 by the mother, my lord, has been gifted, my lord, to the other brothers on, my lord, 8th of August 2006. my lord, my point is, my lord, admitted case is, my lord, on 7th of August 2006, the father, who is one of the attesting witness of the 2006 deed, he was admitted in hospital. Now, my lord, on 8th, my lord, and my lord, it has also come up in evidence that mother was looking, but the father was ill for quite some time. Mother was looking after the my lord father. On 7th, my lord, he was, my lord, hospitalized. On 8th, mother has gone and executed a deed, and my lord, the attesting witness was the father. My lord, how far is this, my lord? May I ask myself, it is
I
believable?
appreciate Mr. Bhattacharya, but isn't it aren't we entering into the domain of facts?
My lord, non-consideration of
first appeal, it would be a very good ground.
the
It is not a non-consideration. That is the difficulty. Considered, you took the point. It must not considered at all.
Considered, my lord, considered in one.
How did the courts proceed on?
Courts proceed, my lord. If your lordship would kind enough to see, may I read this portion? In appeal, 3 deeds of gifts of the plaintiffs have been admitted in evidence. The plaintiffs have also filed discharge certificate of their father, that the date of admission is noted, but no date of discharge mentioned. However, it shows that he was admitted in hospital on 7th of August 2006. He was a witness to the deed of the defendants. Plaintiff took no steps for verification of the signature of the said witness by an expert. Presence of the witness before the registrar is not necessary. He executed a sale deed on the next day. So the ground that as he was not confined, he was confined in hospital bed, was not possible for him to be treated as a witness to the deed of gift of the defendant, has no impact on the validity of the disputed given. This is the my lord finding. My lord, there is also, my lord, another, my lord, submission. Kindly see, my lord, the learned judge records, my lord, on the next day, that is, my lord, 7th, 8th, and on 9th August, presumably on the next day, 9th August, the father executed a deed.
8th August.
The recording is on the next day of 8th August. Then, my lord, 9th of August.
What happened?
The father himself executed deed in favor of third parties. My lord, court, my lord, with deepest of respect, does not come into any finding whether the father went to the registry office, whether the commission, it was done on commission, nothing regarding that.
That was your burden to prove. But yes, you may have. But Mr. Bhattacharya, the witness, the court says that the witness need not be present in the registration office, which is correct.
Kindly see, my lord, mother, from the mother's perspective also. My lord, the mother who was looking after the father on, my lord, 7th, father was at, my lord, that is also admitted case, because
father herself did not challenge.
My lord, yes, mother was alive till 2009. Mother was alive, my lord.
3 years after that.
Yes. I do not know whether it was, my lord.
Mother herself executed.
Yes, mother herself executed.
Then,
my lord, this is, my lord, the only, my lord, and concurrent finding of both the courts. This is the concurrent finding of both.
What judgment is?
My lord, one
perversity. Perversity.
One, my lord, Santosh Hajari, my lord, notes, and the very recent judgment, my lord.
Will accept your proposition that perversity is a good ground. Sorry, sir.
This is the only, my lord. Otherwise,
fair enough. Fair enough. The present appeal has been preferred against a judgment of affirmance whereby both the courts dismiss the suit of the plaintiff stroke appellants for cancellation of a gift deed executed by the mother of the parties on August 8, 2006. For the next parallel, Learned Counsel appearing for the appellants submits that a document was produced, exhibited in the suit, indicating that the father was admitted in hospital on August 7, 2006, the date immediately prior to the purported date of execution of the gift deed. Thus, it was not credible that he signed as the attesting witness of the impugned gift deed on the very next date. Next para, Learned Counsel submits that the courts below also found that the father himself had executed a deed in favor of other parties on August 9, 2006. Full stop. Next para. However, comma, it is contended that the foundational facts establishing the father's presence were not looked into by the trial court, by the courts below at all. Full stop. Next para. However, comma, we find on a perusal of the judgments of the courts below and upon hearing learned counsel for the appellants, that the appellants are the sons of the donor in the impugned gift deed dated August 8, 2006. So further, comma, the donor herself, that is the mother of the parties, comma, was alive till the year 2009, comma, about 3 years after the execution of the gift deed, but did not assail the same. Full stop. Next para. Only after her demise, comma, the present suit was filed by the appellants, comma, that too not for a declaration that the deed is not binding on them, but for cancellation of the deed outright. Full stop. Next para. The courts below proceeded on the premise that the presence of the attesting witness in the registration office at the time of registration of a deed is not necessary in law. Full stop. Next para. Secondly, comma, it was also found that no attempt was made on the part of the plaintiffs stroke appellants to examine the veracity of the signature of the father, comma, who featured as an attesting witness in the gift deed. Full stop. Thus, comma, in the absence of any proof as to the said gift deed being a manufactured one, comma, both the courts dismiss the suit. Full stop. Next para. Learned counsel for the appellants argues that if judgments are tainted by perversity for non-consideration of vital evidence and or consideration of evidence which is extraneous in nature, sorry, comma, affords a good ground, affords a substantial question of law for admission of a second appeal. Full stop. Next para. However, comma, in the present case, comma, the appellants have not made out a case that the learned courts below did not appreciate or look into the evidence at all and stroke or took into account evidence which was irrelevant for the purpose of the adjudication. Full stop. Rather, comma, both the courts have entered their concurrent findings on facts, comma, by an appreciation of the evidence on record. Full stop. Next para. It is entirely beyond the scope of a second appeal to reappreciate the evidence upon a factual consideration, comma, thereby disturbing the concurrent findings of facts arrived at by both the courts. Full stop. Thus, comma, we do not find any substantial question of law being disclosed. Accordingly, SAT 346 of 2017 is dismissed under order 41 rule 11 of the Code of Civil Procedure. Consequentially, তিনটে can আছে আলাদা করে দিয়ে
Already hello. Section 5 is restoration and stay.
আচ্ছা, can 3 then, which is
Only one. Stay is only one. Can.
accordingly can 1 of 2017 within bracket old number can 9765 of 2017 bracket close stands dismissed as well. No orders to cause any. Sorry, Mr. Please.
My lord, I am for the appellant, my lord.
Yes.
Advocate on record, Shomi Go Thagurata is not.
Please use the microphone, ma'am.
The advocate on record, Shomi Go Thagurata is
No,
not.
on the last occasion we granted time.
My lord, I
Not a
have the
secretary.
prescription, my lord. Doctors.
No, whatever. Should have made alternative arrangements.
My lord,
This is a
At least
second
2 weeks
occasion when
time.
adjournment is sought on the ground of the ailment of learned advocate for the appellants. Full stop. Let the matter go out of the list. We're not dismissing the matter since he's ill, but out of the list. Yes. First time.
22.
21. 21. Yes, 22. What are the defects?
My lord,
Several defects.
the defects were all cured, my lord.
All cured.
Defects are all cured. That's my instruction.
Yes. What is the matter?
My lord,
I was the plaintiff in the suit under premises tenancy act. Suit was decreed in my favor on the ground of defaulter. The defendant had been defaulting for good 3-4 years. The first appeal court reversed the judgment on the grounds of notice that my suit is premature. It was what has been held by the, well, I will kindly come to the order. This, my lord, will find that page 3 first, my lord, internal of the first. Yes. My lord. Premises tenancy act বইটা তো
What do you say to this?
My lord, prior to that, my lord will kindly come to the observation and the finding of the first appeal court, which my lord will find that
first appeal or first court? Trial court.
The trial court. I stand correct.
Yes.
Trial court. That my lord will find that the internal page my lord 6. My lord, issue 3 and 3 to 6 is being decided from the at issue 3 and 6.
Where is the notice point specifically dealt with?
Yes, my lord, I'll come to that. My lord, that is issue 3 and 6. This is the defaulter ground, and the notice point has been dealt with at page 8, my lord. The last part of it. Page
8 of the trial.
That was 6 page. The 3 to 6. কোনটা page 8 বাবা, আমি তো দেখতে পাচ্ছি না, আমার ব্রিফে নেই।
The notice was for expiry with the month of July. But you filed the suit before that.
Well, the suit was admittedly filed on
16th July.
16th July. Well, there was, well, defense was struck off in the first appeal court, but I understand, my lord, because
No,
if
but
the
this suit
if the
based on
suit
the foundational.
Well, now, my lord, now I'm on a different ground altogether. My lord, kindly come to the finding of the first appeal court. Well, first appeal court in this part is coming on deciding on a question of facts now. It's reappreciating the question of facts. Now, while reappreciating the question of facts, my lord, how the first appeal court is dealing with the evidences. Now, my lord, we know that if an exhibit is to be dealt with, my lord, the content has to be proved. My lord, this has to be clear and speaking order. My lord,
this must have been an exhibit in the suit.
Correct, my lord.
You had to prove it.
That it is. Notice has been notice. Well, if a notice is an exhibit, well, the contents of the notice also requires to be proved.
No, if the notice, the date at least. I mean, unless if you did not prove the notice, then your suit would automatically fail.
I have proven the
So if
notice.
you have proven that, and that is what is considered by the court. And court is correct, appellate court. Trial court tangentially went off. Started with the right thing at internal page.
I have seen that.
Yes, you must have seen it.
I know, my lord, but my lord will kindly, my lord, I'm just on the
issue of fresh notice, issue of fresh suit. It's easy to say, difficult to do. You understand? But appeal court was correct.
Well, appeal court was correct, but my lord will kindly come.
Language of 6 is very
kindly
clear.
pause and consider, my lord, how it has been factually appreciated.
How else would it be appreciated?
Well, if it is deciding on a question of facts and, my lord, how it has arrived at, it's just the exhibit. It's saying, my lord, may I just read this part of it?
Dates are not disputed. These are the dates. Trial court also finds these dates.
Well, it says
the filing of the suit is, I mean, it must be an admitted fact.
Yes, absolutely. I understand that, my lord. I'm just. Well, here's a PW1. Is this evidence?
Yes.
First appeal. PW1 evidence has stated the plaintiff through learned advocate notice to quit dated 4th June 2018 to the defendant in suit property by way through registered post with AD under 64 such and such by asking the defendant to quit and vacate the suit premises within the expiry of the last date of July 2018. My lord,
yes.
In the notice, the notice was worded that within 1 month you are supposed to get. My lord,
you issue the notice itself on 4th of June. It has to end with a month of the tenancy. Could not have
1
ended
month
with
of
June.
tenancy. It could not have
ending with a month of the tenancy.
ended with a month.
So only
clear
July.
month.
Before July, it could not have.
31st July would have been the
No,
threshold.
waited for some more time. Bad advice, but you suffered. Then we done. Sorry. The present second appeal has been preferred against the judgment of reversal. First up, in the trial court, the plaintiff stroke appellant obtained a decree of eviction on the ground of default under the West Bengal Premises Tenancy Act 1997, which was reversed by the first appellate court on the sole ground that the eviction notice was premature. First up, learned counsel appearing for the appellant submits that the first appellate court did not properly appreciate the facts of the case by undertaking a proper inquiry on the contents of the notice. First up, next para, however, from the admitted position, as recorded by both the courts, we find that the notice under section 6 within bracket 4 of the 1997 Act itself, in the present case, was issued on June 4, 2018, whereas the suit was filed on July 16, 2018. First up, as per section 6 within bracket 4 of the 1997 Act, which incorporates a non-obstante clause, no suit for recovery of possession of any premises under the said Act on any of the grounds enumerated in section 6, except on the ground mentioned in clause small e of subsection 1, shall be instituted by the landlord unless he has given the subtenant, double inverted, open inverted, 1 month apostrophe notice expiring with a month of the tenancy, unquote, full stop. Next para, hence, if the notice in the present case was itself issued on June 4, 2018, a clear 1 month expiring with the month of the tenancy would evidently not expire prior to the end of the month of July 2018, whereas the suit was filed on July 16, 2018. Full stop. Thus, ex facie, the suit was not maintainable, the cause of action itself being vitiated. Full stop. Accordingly, we do not find any question of law involved. Accordingly, SAT 57 of 2026 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. There will be no orders to cause urgent certified copies. Sorry. Huh? No, I can't find Inform the other side.
That is number 23.
I am for the appellant, my lord. Suit for declaration and permanent injunction. Judgment against apportion. Both the trial court and appellate court dismiss the suit. The short point involved is that, my lord,
declaration of your title.
Title and position. Practically, declaration of position and injunction not to dispose of him by the defendants. Both the court held that I am in position. CSRR, thereafter RSRR and LRR, or admitted in my favor. Both the trial court and the appellate court held, yes, we are in position.
One second. Did you direct you to serve copy? No, then they refer it. There cannot be any service without direction of court. We have not admitted you served. Yes, please carry on.
Then, my lord, but
both the courts held
that I am in plaintiffs are in position.
CS records are in your name.
Yes, my lord. CS, RS, LR.
Oh, that's it.
And in the year 1995, a comment added in the LR records that for common use for common people, sadhana by virtue. Thereafter, my lord, defendants tried to take possession of the said plot of land, that is plot number 371. Two plots are there. So far 359 is there, there is no dispute. In the written statement, defendants admitted that we are in possession. They also admitted that there is no construction, nothing. That is the Kali temple has been established according to them. That is the LR records I also stated. There is the Kali temple. Now nothing is there, my lord. They admitted that we are in possession. Kali temple situated plot number 370,
If
but
it's recorded, it's for use of the public. Then how can you say you are in exclusive possession, in exclusion of the public?
that is, my lord, what I'm submitting, my lord, that is the wrong committed by the concerned authority. So I filed an application for correction of the same. But here the point is, I mean, that is the issue here. Subject correction, that is not the issue here.
But then you could not get a declaration of your possession on that.
Their point is that, well, they're saying, all right, we are in possession, but you have no title deeds. So when you have title deeds,
Not a single title deed was produced.
no, my lord, no title deed is there.
Then
From records of right,
record of right cannot be proof of title.
no, I'm not paying for title. What I'm submitting, my lord?
Declaration of title is the first thing before possession.
The declaration,
Cannot ask for declaration of possession without title in this case. It's disputed.
but my lord, though I am not possession, but I have no title. But there's a judgment of, I have seen subject to correction, my lord, that honorable court says if somebody is possession, the third party cannot dispossess
Your
him.
possession is also under doubt. সাধারণে ব্যবহার্য does not mean you are in exclusive possession.
That is the portion.
It's an undemarcated property. সাধারণে ব্যবহার্য, how can it be a portion?
No, no, comment করো, সাধারণ ব্যবহার্য করেছে।
যেটা প্রডিউস করছে তারই দেখায় সাধারণে ব্যবহার্য। টাইটেলও নেই।
Plot number এটা 336 না?
This is a bad case.
এর নাম্বার চেঞ্জ হয়ে গেছে? আচ্ছা।
CS, LR, RS, LR.
LR, number.
All show your name, but সাধারণে ব্যবহার্য।
No, only in LR.
That is the latest you produce that.
Yes, that is saying, my lord.
And in the absence of title, how could this declaration be granted? You must have asked for declaration of title first, then possession.
Yes,
You did not ask for title.
Yes, I asked for title. You also can see page 28 of my application for injunction, can 1. Can 1, page 28.
No, the plaint.
That is the plaint, my lord.
Oh,
can 1, page 20.
Oh, can. Sorry. Yes.
Page 20, it is written in
সত্ত্বীয় দখলি সাব্যস্ত।
Yes, সত্ত্বীয় দখলি সাব্যস্ত, সত্ত্বীয় দখলি সম্পত্তি থাকা সাব্যস্ত এবং নালিশি সম্পত্তি বাদীগণ আর্জি বর্ণিত মতে undivided.
How can you be in occupation of a portion of an undivided property?
It is, my lord,
admitted to be undivided.
Undivided among the co-shares, among the plaintiffs. Defendant has not adopted that interest over the property. The third party, my lord, admittedly.
You don't have any title deed. How can the court grant a declaration of title?
My lord, only one
Possession follows because as per the frame of your suit.
Subject to caution, only one point is there. Take judgment. My lord, kindly consider identical situation arises before the honorable court. It to give, that one also hits me, my lord. But kindly see the last paragraph of the judgment. Factual aspects are same. The same.
This is not binding on a division bench.
It is admitted by the honorable.
This is not binding on a division bench.
No, admitted by division bench. Second appeal, my lord.
This was final hearing.
Final hearing before the single bench.
And a single judge.
Before the single judge, but admitted before the honorable.
Which portion of it you are relying on?
Just last one, 72, paragraph number 24. Therefore, if this factual position remains unaltered, that a position is in the possessory column was recorded in favor of the plaintiff since CSRR, it is sufficiently indicative that at some point of time, the plaintiff's predecessor sat possession over the property way back in 1920-26.
No, this was different. It was not সাধারণে ব্যবহার্য।
Not
possession.
Possession of title does not arise. But yes, not
সাধারণে ব্যবহার্য was not there.
Not mentioned, but point is that, my lord, that recording we have already challenged for the competent authority. We have not get any notice. Without giving notice.
Till date you have it's pending. So what? How can the civil court grant? And the frame of your suit is such that your possession follows your title. সত্ত্বীয় সত্ত্বীয় দখলি সম্পত্তি.
Yes, that's true.
Where is that?
That's true. You have never sale deed or in a document to show that we are the owner of the property.
The present second appeal has been preferred against a judgment of affirmance whereby both the courts dismiss the suit filed by the plaintiff appellant for declaration, plaintiff's appellants for declaration of the title and possession and for consequential reliefs. Full stop. Next para, learned counsel for the appellants argues that in the CS, RS and LR records of rights, consistently the plaintiff stroke appellant's names were recorded. Full stop. However, there was a rider only in the LR records of rights, which indicated that the subject property is for common use of the public. Full stop. Learned counsel submits that in view of the presumption created by the CS and RS records and the entries therein, the courts below ought to have held at least that the plaintiffs stroke appellants are in possession of the property. Full stop. Next para, learned counsel cites a judgment of a learned single judge of this court in the matter of Vishwanath Chongdar and others versus Sudha Ghosh and others, reported at 2019 Supreme within bracket Cal 280, where the learned single judge observed that if the factual position remains unaltered that a position in the possessory column was recorded in favor of the plaintiffs, since CS, ROR and RS ROR, it is sufficiently indicative that at some point of time the plaintiff's predecessors had possession over the suit property way back in 1925-26 when the CS ROR were prepared, and following such noting RS ROR was also prepared, which at least shows the possession undisturbed, effective and settled possession of the plaintiffs in respect of the suit property for a long time, if not, ripened into a title, but there is no justification to disturb such possession as on that date. For the next para, however, from the said proposition itself, it is evident that even long possession on the strength of entries in the records of rights cannot acquire the character of title. Full stop. Next para, it is quite well settled that entries in the records of rights do not confer or take away the title in respect of the subject property. Full stop. Next para, as per the frame of the suit, possession followed title. In the absence of any title deed whatsoever being produced by the appellants in the trial in either of the courts below, the consequential relief of declaration of possession could not also have been granted. Full stop. Next para, more importantly, from the last document of possession, that is the LR records furnished by the plaintiffs appellants themselves, it is evident that the property has been recorded for the use of the common public. Full stop. If that be so, the courts below could not have granted a declaration of exclusive possession of the plaintiff stroke appellants in respect of the subject property. Full stop. Next para, thus, we do not find any illegality or error of law and or fact in the concurrent findings of the courts below. Full stop. Next para. Moreover, the facts and circumstances of the cited decision were completely different from the present case, inasmuch as the possession, the recording of the names of the plaintiffs appellants in the LR records of rights produced by themselves clearly indicated that the plaintiffs were not in exclusive possession, but their possession was qualified by right of the common public to use the subject property, thus disentitling the plaintiffs appellants from the declaration as sought for. Accordingly, SAT 21 of 2026 is dismissed under order for Rule 11 of the Code of Civil Procedure. Can 1 of 2026 is consequentially dismissed as well in order for service.
No, no. That is not. No.
Number 24.
24, I am for the appellants here. But before submission, I tender my apology for the defect.
We accept what? Why?
Because some defects are there, but most of the defects have been rectified. But
apology won't do. You have to cure the defects.
Yes, my lord. That only one main defect is these, my lord.
Defects are removed, it appears.
My lord, I have applied for certified copy of the judgment of the title suit, my lord. That is the 31st of July 2026. Therefore, my lord, I paying for my lord
appeal
accommodation for a week, my lord. It will be available after a week.
Trial court judgment is not there.
Yes, my lord. Because in title appeal, that was affirmed that judgment.
Then this goes out of the list when you file.
Just 1 week, my lord. I shall
no,
go.
no.
Only 1 week, my lord.
No.
Next Monday, it will kindly, my lord. Well, my lord.
Learned counsel for the appellants seeks an adjournment for filing the certified copies of the judgment and decree of the trial court. Full stop. Accordingly, the matter is adjourned till August 17, 2026 as a last chance to the appellants to file such application, to file such certified copies. Full stop. In default, comma, the matter may be directed to go out of the list. Please given me.
Item number 25.
Lord, I beg that.
Yes, sir.
At the very outset, my lord, I must congratulate my lord, Justice Sandeep Dev, my lord, for his allegations.
Thank you. I'll pass the order. At least in this matter. Yes.
My lord,
Yes. Not file. Trial court.
Trial court.
You can take it if you
Kindly excuse me, my lord. I mean,
what else? Any other defect?
other defects are removed.
Have you checked up?
Check on it, so.
Yes, what is that?
Now, my lord, this is my lord, defendant appellants.
Yes.
My lord, lost in both the court. Suit for recovery of possession, my lord. Suit for eviction and recovery of possession.
Under? I mean, as a trespasser?
Yes. Now, my lord, the fact is this, my lord, one Kolani Dasgupta, along with his son, my lord, Deepak Dasgupta, daughter Deepali Dasgupta, and my lord, the brother-in-law of Kolani Dasgupta, Dhirendranath Dasgupta, my lord, came to India in the year 1949. Now, subsequently, my lord,
from East Pakistan?
Yes.
Yes.
Now, subsequently, my lord, what happened, my lord, Refugee Relief and Rehabilitation Department, my lord, issued a letter of, my lord, allotment, my lord, in describing the names of 4 persons as the beneficiary of, my lord, this land in question. Now, my lord, subsequently, my lord, this letter of allotment was issued in where the, my lord, beneficiary of this, my lord, there is, my lord, Kolani Dasgupta, his daughter, his son, and my lord, one Dhirendranath Dasgupta. Now, my lord, that is there, my lord, exhibit 7. I shall place to your lordship, my lord.
Right now, need not?
Yes. Now, my lord, what happened, my lord?
So she was your predecessor? The appellant's predecessor?
No, my lord. So far as my predecessor is concerned, my lord, my predecessor is, my lord, Dhirendranath Dasgupta.
His name was also recorded.
Yes. I am claiming right, my lord, on behalf of, through, my lord, Dhirendranath Dasgupta. So, my lord, the wife of Dhirendranath Dasgupta, my lord, filed a partition suit in the year, my lord, 2004. Now, my lord, that partition suit was dismissed.
Your mother?
But my lord, predecessor in interest, so far as my lord, Niva Dasgupta
is your mother.
Niva Dasgupta, my lord, so far as we are concerned, my lord,
you said you are the daughters of Dhirendra, you are not.
No. So far as Niva, my lord, we describe ourselves, my lord, as the adopted daughter of my lord, Niva Dasgupta, but we could not prove it.
Who is Niva Dasgupta? One of the daughters of Kolani?
No, Niva Dasgupta is the wife of my lord, Dhirendranath Dasgupta. Well, 4 persons are there, my lord. Kolani Dasgupta, his daughter, my lord, Deepali Dasgupta, his son, Deepak Dasgupta, and my lord, Dhirendranath Dasgupta. Dhirendranath Dasgupta is the brother-in-law of Kolani Dasgupta. So 4 persons, my lord, came to India, my lord, the letter of allotment in the name of the 4 persons. My lord, Dhirendranath Dasgupta, my lord, married Niva Dasgupta. I am claiming, my lord, through Niva Dasgupta. Niva Dasgupta, my lord, executed deed of gift in respect of the property in question in my favors, in favor of us. Now, my lord, the Niva Dasgupta, my lord, filed a suit for partition. That partition suit was dismissed, stating that as because the deed of gift was not executed by the state of West Bengal, by the RR government, so nobody has any right title interest in respect of the property in question. So, my lord, that suit was dismissed. Now, appeal was filed. Appeal, my lord, could not be proceeded with as because the Niva Dasgupta died in the meantime, my lord, appeal abated. Thereafter, my lord, what happened? These plaintiffs filed a suit for eviction stating that you are the trespasser, So that suit was decreed in favor of the plaintiffs.
These plaintiffs, the
These
present
plaintiffs.
respondents, they are the heirs of the other.
Yes, heirs of Kalyani Dasgupta. Heirs of Kalyani Dasgupta. Now, this suit was filed by the heirs of Kalyani Dasgupta. The suit was decreed.
If your predecessor Niva's suit failed, then how can you?
Now, the question is, the trial court finding and appeal court finding, both the courts.
Niva executed a gift deed in your favor.
In my favor.
So Niva filed that suit.
No, Niva filed the suit. Yes, Niva filed the suit for partition.
For partition.
Suit for partition. Now, the partition suit was dismissed, stating that look here,
the parties there also.
Niva was party. I am claiming through Niva.
Acha, Niva was a party. She filed a partition suit against the others.
Niva filed a partition suit against Kalyani
and
Deepak. Yes.
That was dismissed.
That was dismissed, stating that look here, that the property has not been, the deed of gift has not been executed by the RR Refugee Relief and Rehabilitation Development. So, there is no title. So,
her suit was dismissed. No title in the property.
My suit, my predecessor interest suit was dismissed. That's because there is no title. Court found that nobody has any title. So far as the predecessor interest of the plaintiffs, they also could not produce the title deed.
No, court's finding was regarding Dhirendranath Dasgupta's execution of a gift deed in favor of Niva. Only.
No, I am not clear. Niva Dasgupta filed a suit for partition stating, the look here, the property initial allotment was made in favor of Kalyani, her sons, as well as Dhirendranath Dasgupta.
Yes, Dhirendranath gifted his share.
Dhirendranath Dasgupta was the husband of Niva.
So he gifted his share to Niva.
No. Niva was claiming rights through Dhirendranath Dasgupta. After the demise of Dhirendranath Dasgupta, Niva became the so-called half share.
Executed the deed.
Niva Dasgupta.
Favor.
Yes. Niva Dasgupta, during the pendency of the partition suit, Niva Dasgupta executed the deed of gift in my favor. Now, in that partition suit, it was found that nobody has any right title interest. Nobody. I am just showing to your lordship the observation. Kindly have a look, the observation of that. Prior to that, if your lordship, kindly turn page, kindly text volume 2 of the application, page 195. Page 195, this is the exhibit 7. It was written by Deputy Controller, Refugee Department, to the Dhirendranath Dasgupta. Dhirendranath Dasgupta is the husband of Niva Dasgupta, through whom I am claiming. With reference to his prayer dated 26th of June 1989, the unassigned is to inform you that the allotment of the plot number 340 Ganguly government scheme was made with the purpose of all members of the family, that is Kalyani Dasgupta, Dhirendranath Dasgupta, Deepali Sengupta, that is Ni Dasgupta, and Deepak Dasgupta, will be the de facto owners of the plot which has been allotted by the government. Moreover, at the time of conferment of the right and title, his prayer will be duly considered, which has been decided by this office on the basis of the local inquiry made by an officer of this office. This was the initial letter of allotment. Subsequently, if you lost kindly text next page, that is page 196. Prior to that, if you lost kindly text page 194 once. Page 194, it is a letter written by Deputy Controller, Refugee Relief and Rehabilitation, Calcutta. Addressed to Kalyani Dasgupta.
We cannot go into evidence.
No, what I am.
Which was the previous finding?
Yes. Kindly text the first, the partition suit, page 136. It is in volume 2. The partition suit filed by Niva.
What is the crucial finding that none?
Yes. Yes. Now, kindly straightway comes to page 179.
Yes. Yes.
May I just place it second paragraph. In view of the decisions reached, the plaintiff failed to prove that 8 shares in the suit property, and thereafter the partition does not arise, and hence no other relief can be granted as preferred. No further discussions is required on these issues. They are accordingly disposed of against the plaintiff, but in favor of the defendants. However, it is made clear that no gift deed has been executed in favor of the allottee Kalyani Dasgupta so far. The property belonged to the Refugee Relief and Rehabilitation Development, Government of West Bengal. So it would be the ultimate decision of the state department as to in whose favor it will execute the deed.
From this, it appears that Kalyani Sengupta was the only allottee.
So, my lord, I have shown to you also Exhibit 7. Exhibit 7, my lord, it was for the my lord, also, my lord, kindly visit this reason. The refugee family came. They are consist of so many family members. They were one my lord described as head of the family. Now, Kolani Dasgupta was the head of the family.
Seemed to be held on behalf of all.
Yes, but it was not the exclusive my lord ownership of Kolani Dasgupta. It was for the benefit of 4 persons.
So,
my lord,
by holding this, it was conclusively decided that none have title.
yes, none. That is my case, my lord. If none has my lord any title,
They have better title then.
so, my lord,
As
both-
allottees de
both-
facto
both-
owners, they have
my lord, 174, 195, my lord, I have shown to you, lordship, my lord. It is for the benefit of 4 persons, not for the benefit of Kolani only. It is for the benefit of 4 persons. When a refugee family when comes, my lord.
Yes, but they were the allottees. Allottees filed an eviction suit against a ranked trespasser. You were a ranked trespasser.
I was one of so far as what is my right, I am also claiming through Dhirendranath Mondal, Dhirendas Gupta.
By virtue of an adoption deed.
No, not by virtue. By virtue of a deed of gift. Deed of gift, I am just giving certain dates, my lord. The Dhirendranath, my lord, married to my lord Niva Dasgupta on 10th March 1992.
Niva executed a gift in your favor.
Niva executed a gift deed in my favor on 14th of June 2010.
So you say whatever right Niva had, the others also have.
Yes. The Niva is also having the same right, where Kolani is also having.
Of the trial court.
The trial court filing, my lord, kindly have a look, my lord, trial court filing.
Both courts, you lost in both courts.
Both courts. No, kindly see, my lord.
Appeal court also.
Appeal court had proceeded on this. Kindly see the trial court first. Kindly see, my lord, page 7 of the inner page 7 of the trial court, sir.
Yes.
Issue number 3. It is in the my lord, Xerox. Issue number 3, my lord, inner page 7. Whether the defendants have any right title interest in respect of the suit property. To determine this, this court has documentary as well as oral evidence on record. To pull up the documentary evidence on record, this court finds that one, namely Niva Dasgupta, under whom the instant defendants claim the suit property, filed a petition suit wherein the court held the said Niva Dasgupta is not the owner of the property. Thus, the claim of the Niva Dasgupta in respect of the half share of the scheduled property has been whittled down by the court. The court also observed that the property belongs to the RR department. As such, the RR department would be the best authority to decide the dispute. On the other hand, these defendants filed several documents showing the communications from the RR department, and the RR department clearly speaks the fact that no deed has been issued in connection with the instant suit property. The defendants also filed certified copy of the deed of gift that is 14 June, issued 14 June 2010. From the said deed, it turns apparent that Niva Dasgupta gifted her share in respect of the suit property in favor of the defendant number 1 and the defendant number 3. The said deed gift was executed in the year 2006.
Now, well, on the strength of this finding of the
it requires consideration.
Still will admit on this ground. Yes, I admit for this chapter. The present second appeal will be heard on the following substantial question of law: whether both the courts below substantially erred in law in decreeing the eviction suit in favor of the plaintiff stroke respondents on the finding that the predecessor in interest of the defendants appellants did not have any title to the suit property, by overlooking the fact that in terms of the judgment dated May 23, 2011, passed in title suit number 109 of 2004, bracket earlier partition suit, bracket closed, neither the plaintiffs nor neither the predecessor of the plaintiffs nor the defendant could have acquired title in respect of the suit property, which ought to have precluded the plaintiff's respondents from the locus standi to obtain an eviction against the defendants, both the plaintiffs and defendants being on the same footing. Push up. Any interim order?
My lord, I file an application, my lord. Page 28, my lord.
There shall be stay of operation of the impugned judgment and decree, and or any execution case, is levied in terms thereof. till disposal of can 1 of 2026, full stop, the appellants shall serve copies of
Caveat is there, my lord, I already
your
served.
appeal.
Yes.
Very well. You want to file any opposition to this?
Yes, Lordship, already appellate court passed on occupation charges.
We have some doubt whether on this ground occupation charges you are entitled to. But we will not say anything of that. You go to the single judge and convince the single judge.
No, because of the
আচ্ছা
appellate court
তাহলে
judgment also
কপি
there.
সার্ভিস তো হবে না affidavits in opposition if any shall be filed by the plaintiff's respondents to can 1 of 2026 within
Within 4 weeks.
within 4 weeks from date, push up reply if any shall be filed within a fortnight thereafter. Push up liberty to the parties to mention the application for inclusion in the list before the appropriate learned single judge, then having determination after the expiry of the above timelines for filing of affidavits is over.
Lordship, regarding occupation charges,
They're not keeping
Lordship,
anything.
already appeal court passed this order to that extent, Lordship.
We have some doubt. Appeal court did not admit on this ground. We are not mentioning anything. We have our, if we were to decide, you would not get it. Because you're on the same footing as them.
Lordship, they claiming as a adopted
Anyway, we
daughter,
have
that
filed.
was failed.
This is not on the basis of adopted daughter. This is on the basis of a gift deed.
That was
Next matter.
claiming loss.
Yes.
There is a 6 days of delay.
Seriously opposed?
Lordship, I appear for the respondent number 1 to 5, Lordship. I'm led by Mr. Rahul Karmakar, Lordship. Lordship, he's stuck in a traffic jam. I'm praying for a
If Mr. Karmakar opposes 6 days delay, we'll impose costs on him.
Lordship had indicated this on the last occasion. Lordship, I'm only.
Why? We had indicated.
Lordship.
So this is the second occasion we are allowing the section. What? You are there. You are for which respondent number 6, my lord? 6.
Lordship, may I kindly just pray for a.
No question of that. No, you are for 6, you are for 1 to 5.
1 to 5.
So 7 to 10, you have to serve them.
7
7 to
to
10 service.
If you have served, then we'll. Was there any direction to serve?
No.
This is for the first time. Then
They were on caveat. That's why we had served them.
Since the respondent number 1 to 6 are represented by separate set of counsel, the appellant shall serve copies of the memorandum of appeal and the connected applications on the respondent number 7 to 10, indicating that the matter shall be listed under the same heading on August 24, 2026, when an affidavit of service to that effect shall be filed by the appellant.
In fact, my lord, I'll tell
Serve
your
everything
lordship,
so that if you can.
I'll tell your lordship, it's a management dispute. It's an order 1 rule 8 suit. 7 to 10 are in fact supporting the supporting our cause.
Get them appear to someone. You just have them appear to someone. You serve. In order to avoid a presumption of collusion, you serve.
No, there is no collusion. There, as your lordship knows, in any company, corporate entity, there is one group in favor, one group against. So 7 to 10 is in my group.
So have them appear
And they are on the other side.
You serve copy, but have them appear to somebody. So you can take it up on the next day and you have to file your affidavit.
Great.
You have right to serve everything so that if possible, we can take up.
Madam. Grateful.
Yes.
Lordship, I'm appearing for the appellant hearing.
Yes.
Lordship, this appeal is arising out of an application.
What are you doing? Yes.
This arising out of Order 39, Rule 1 and 2, passed in a title suit by Civil Judge Senior Division, Bonga. Lordship, suit for title suit. Title suit for partition.
So what is your ground of challenge?
Lordship, the ground for challenge is it's an injunction order and the impugn order. Lordship may kindly take the
nature, character and position.
Lordship, the nature, character and position, there's injunction order for not changing it. Lordship may kindly take the trouble to come to the impugned order. I will show that there is no prima facie case. There is no findings of the balance of convenience and inconvenience. And obviously there is no irreparable injury that is mentioned and that is being found in this impugned order.
Let us start from the last paragraph of the first page.
Lordship, the first paragraph is for the substitution of the respondent.
Forget that. After the bold letter, the petition.
Lordship may kindly take the trouble to come to the second page.
Second para. Second page, second para.
Second para.
Better.
Lordship, may I read it out?
Please.
The plaintiffs as well the defendants have claimed to be the co-sharers of the schedule mentioned.
Sorry, we thought you were starting from considered the facts. You're starting from where?
Lordship, 4 lines down.
What? Yes.
Lordship.
Yes, yes, please.
The plaintiffs as well the defendants have claimed to be the co-sharers of the schedule mentioned suit property, and it is also admitted. Lordship, it is not admitted in my humble submission. And Lordship, 2 lines down, the computer's information with regard to the plot number 2254 has been filed before the court, and it appears that the plaintiffs as well as the defendants of the suit are co-sharers of the suit plot. Lordship, they are not co-sharers, they are the co-owners. From the documents, I will show that they have the LR ROR in their record.
Both of your names are recorded.
Lordship.
So you are obviously co-sharer.
Lordship, I am just giving a history of this matter. That is, I have brought a land from the pro forma respondent herein. The area that I'm holding is just 0.03 acres of land, and that is
Not demarcated, you cannot have a specific area.
Lordship, in the schedule when I have brought the property in 2023.
Co-sharers cannot sell a particular portion of the demarcated property if there is no partition in the first place. Both of us are co-sharers. I can sell my share to you. I cannot sell a demarcated portion because he has right title interest over every inch of the.
Lordship, when I brought the property, this whole
It would be he will get his share.
the whole suit property is of 0.23 acres, and when I brought the property, the from whom I have brought, he was holding this whole 0.23 acres. There was no dispute at that point of time.
He was not the owner of the whole.
From whom I have brought, that person was holding whole suit property and
sole owner.
Lordship. But somehow the respondents herein, the pro forma respondent is claiming that they have forged those documents and they have now claiming that they are in possession. But when I have brought the suit property in 2023, that time he was the sole owner of that property. I was not aware that he has some other.
Admitting the appeal, you serve copies of the memo and the injunction, but we cannot grant a stay of this. Stay of injunction
Lordship,
is
Lordship,
allowing the appeal. Not at this time. Arguable questions having been raised, FMAT 223 of 2026 is admitted, to be heard on the grounds taken in the memorandum of appeal. The appellant shall serve copies of the memorandum of appeal as well as scan 1 of 2026 on the respondents, indicating that the matter shall next be listed under the heading application in the month list of September 2026, when an affidavit of service to that effect shall be filed by the appellants. We are not recording that, we are not granting either.
I appear for the appellant.
Yes.
Manisu, I was the plaintiff arising out from rejection of application under Order 39, Rule 1 and 2.
Order 39, Rule 1 and 2 in the money suit?
Kindly have a
look.
look.
In the nature of an attachment before judgment then?
No. Kindly have a look. Before starting, kindly have a look at page 154 of my injunction application. The order of division decided over by Judge Harpreet Contribute Banerjee.
You have asked for an injunction. What money suit?
Credit
you owe money to them. You have paid for an injunction restraining them from demanding an amount of money from you.
Credit card fraud.
You deposit the entire amount and get an injunction, will grant direct.
Kindly hear me for 2 minutes there.
Use the microphone. Those 2 minutes have to be in the microphone.
Credit card fraud of 2,99,000 and odd.
Other side is a bank.
Yes. Now, it took place on 24th.
What is the national head of RBI? Who is the national head of RBI?
Head office is in Bombay.
National head you have stated.
Yes, because Kolkata they have
credit card division. Anyway, so there was a credit card fraud. You complained.
Complaint lodged on the same day. 7 different transactions took place between 110 to 119.
Credit card was of which bank?
RBL Bank. I received a phone call from unknown number. The person who called me told me that I am calling from customer care. Thereafter,
let us not go into the details of
disputed question.
You allege of credit card fraud.
Thereafter, at 1:15, I lost the complaint. Subsequently, I was in phone call from 1:15 to the rest of the period, So I have not served any OTPs to them.
what is the meaning of this injunction? By virtue of this injunction,
No, they
you
are
virtually violating the specifically fact. You are seeking an injunction in the nature of restraining them from filing a money suit, which you cannot do. If they file a money suit, you contest that. You cannot seek an injunction restraining them from demanding money. That would be only by way of filing a money suit. So virtually, this is contrary to the specifically fact which says you cannot get an
but they
injunction
are claiming
restraining somebody from filing a suit.
2 lakhs
Before
and
a judicial
90
sorry.
2 lakhs and 99,000 has been debited from my credit card wallet.
But you
They
seek
are
an injunction, they cannot demand that amount from you.
yes, because on the basis of page 92, will it kindly have a look? Page 92.
92, what is there?
Will it I'm saying that.
9.
Page 92.
Page 92, clause 9.
No, 6, 7, and 8.
Achha, yes.
6 minute provides that a customer's entitlement to zero liability shall arise where the unauthorized transaction occurs in the following events: contributory fraud, negligence, deficiency on part of the bank. Transaction is reported by the customer. This is the first condition. I have reported on the same day. Third party breach, where the deficiency lies neither with the bank nor with the customer, but lies elsewhere in the system, and the customer notifies the bank within 3 working days of receiving the communication from the bank regarding unauthorized transaction. Second point, Millard, I have admitted that I have given the credit card number and the expiry date and not OTP. Now the bank's statement is that I have contributed it's a negligence on my part. I am the part of the contributory negligence. They will kindly take their words. Then clause 7, in case where the loss is due to negligence by a customer, such as where he has shared the payment credentials. What is allegation against me? The customer will bear the entire loss until he reports the unauthorized transaction to the bank. Any loss occurring after the reporting of the unauthorized transaction shall be borne by the bank. Milad, I have reported started from 112, 3 transactions took place. I reported at 115. I have stated in paragraph number 10. So Milad, if your lordship takes their words,
the transactions went on till
119.
So after 115, there were certain transactions.
Milad, I have made a flow chart. Milad, kindly have a look at Milad, my flow chart at page 5. Milad, my contention is that since I have not shared the OTP, I have not contributed.
Junction stage, how can you do this? Because trial.
Milad, even after Milad 115.
And this injunction is not maintainable in law. You are restraining them from filing a money suit, basically.
Milad, kindly.
If they take out a money suit, then contest that.
But otherwise, they are claiming 3,39,000 from me.
You can't restrain them from claiming that. If they actually file a
Milad,
suit.
what language they are using, Milad? I will not utter in the open court. Kindly have a look at page 83 once. What language they are sending me in my WhatsApp message?
Then you could have filed a case for defamation.
Page 83.
This cannot be them. Bank will write this.
Yes.
No.
Recovery agents. The next page.
Without evidence, we cannot. This is a photocopy of certain supposedly.
I am protected by page 92, Milad. Zero liability. The suit is for Milad. Suit is for compensation.
At least an arguable case whether. No, first of all, this injunction is not maintainable. Restraining someone from filing a money suit, basically. You have sought an injunction restraining them from making a money claim against you. How can we injunct somebody from making a claim? If they make a claim, you can contest that. Why was it refused? And it's arguable whether there was negligence on your part of the bank.
The certified copy at memorandum of appeal. Milad, no discussion, Milad, regarding Milad prima facie case, balance of convenience and inconvenience, and
otherwise we don't find any reason to interfere.
It is observed, Milad, that I failed to create any urgency, show any urgency to the Lord High Court.
Will not interfere. You let them file their written objection. Let the injunction. This will not bind you at this. You will not interfere.
And Milad, this language is Milad.
You cannot get an injunction from restraining somebody from filing a money suit. This amounts to that.
My lord, at least restrain them from using those languages, my lord.
Language you don't know. There's no allegation about the and language that is on the ground of defamation. This is not a defamation suit. The present challenge has been preferred against an order whereby ad interim prayer for injunction made by the plaintiff appellant was refused. First of the plaintiff stroke appellant seeks to make out a case of being a victim of credit card fraud. First of learned counsel submits that at 1:15 p.m. on the fateful day, the plaintiff stroke appellant reported the incident upon first discovering that he was being swindled on his credit card. First up, thereafter, the offending acts of siphoning of amount from his credit card account continued at least for 4 minutes thereafter till 1:19 p.m. For the next para, learned counsel places reliance on the contract between the parties, in particular clauses 6 and 7 thereof, which indicates that a customer apostrophe's entitlement to zero liability shall arise where the unauthorized transaction occurs in certain events, including contributory fraud, stroke negligence, stroke deficiency on the part of the bank, bracket, irrespective of whether or not the transaction is reported by the customer, bracket close, and third party breach where the deficiency lies neither with the bank nor with the customer but elsewhere in the system, and the customer notifies the bank within 3 working days of receiving the communication from the bank regarding the unauthorized transaction. Push up again, in clause 7 within bracket Roman I, it is provided that a customer shall be liable for loss occurring due to unauthorized transaction in cases where the loss is due to negligence by a customer, such as where he has shared the payment credentials, in which case the customer will bear the entire loss until he reports the unauthorized transaction to the bank. Push up any loss occurring after the reporting of the unauthorized transaction shall be borne by the bank. Push up next para. Learned counsel submits that in the present case, the offending acts of siphoning of amounts from the credit card account of the appellant continued even after the appellant stroke customer reporting the incident with the bank, and as such, the provisions of clause 7 within bracket small I will be applicable to the extent that any loss occurring thereafter shall not be borne by the appellant but the bank. Full stop next para. Be that as it may, we find that the nature in which the injunction prayer was couched in the trial court tantamounts to seeking an injunction restraining the defendant bank from initiating a money claim, a legal action for money claim against the plaintiff stroke appellant. Full stop next para. Such an injunction cannot be granted within the contemplation of the Specific Relief Act 1963. Full stop next para. The injunction sought was restraining the defendants 1 and 2 from demanding the disputed amount from the plaintiff or from compelling him to pay the amount, which can only be done by filing a proper money suit. Full stop. Thus, the ad interim injunction, if granted at this stage, would amount to violate the provisions of the 1963 Act to that extent. Full stop. Next para. Even otherwise, a certain amount of foundational facts are required to be proved in order to invoke the clauses of the contract between the bank and the appellant, which are relied on, which can only be done upon exchange of affidavits in connection with the injunction application in the least. First up, next para. Hence, we do not find any reason to interfere at this stage. FMET 244 of 2026 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. Can 1 of 2026 is also consequentially dismissed. Full stop. We make it clear that the above observations or the observations made in the impugned order shall be treated to be tentative and shall not influence the learned trial judge while disposing of the main injunction application. Full stop. No orders to cause.
Lordships, I'm for the plaintiff, my lord. Plaintiff is 96 years old. And
plaintiff is
96 years old. And he filed a suit for partition, declaration, and injunction against the defendant. And in respect of the joint property, I have annexed all the title deeds whereby I have also annexed with the application for injunction, whereby I am one of the purchaser. And the defendants, the predecessors of the other purchaser, they are the defendants. I prefer not to change the nature and character of the, not to make construction, not to transfer the property. The learned trial could refuse my ad interim injunction, against which I prefer this appeal.
Why you refused? Let us see. Last year আগে তো আর কারণটা কি 96 years old তার মানে মাইনর ছিল
Minor, so I am 96, I am not honored.
Yes.
At the time of purchase, I was minor, but at present I am not honored.
মাইনর রিসিভ করতে অসুবিধা নেই মাইনর ট্রান্সফার
Minor purchase property.
পারচেজ তো করতে পারি আমি ধর মাইনর আমার নামে কি আমার নামে কিনতে পারি কিনতে পারি আমি ট্রান্সফার করলে আমার ইন্টারেস্ট ছিল Learned counsel for the appellant, plaintiff stroke appellant argues that the plaintiff is 96 years old. Full stop. The learned trial judge, by the impugned order, dismiss the appellant's application for injunction in connection with the suit is for declaration of
Partition.
in a suit for partition filed by the appellant on the sole ground that if the plaintiff stroke appellant is 96 years old now, he would have been a minor when the two registered deeds of sale, by dint of which he claims title, were executed. Full stop. Next para. However, we find that the said ground itself was not sufficient to refuse injunction, particularly since title deeds had been produced by the plaintiff stroke appellant, sufficient to make out a prima facie case. Full stop. There is no legal bar ordinarily for a minor to purchase a property, although a bar operates in the event the property of a minor is transferred without legal necessity or without the leave of court. Thus, we fail to understand the logic for refusing the ad interim injunction. Injunction application was refused of an ad interim injunction. Next para. Accordingly, FMA 926 of 2026 is admitted and shall be heard on the above questions and the other grounds taken in the memorandum of appeal. The respondents and not the main agents shall remain restrained by an order of injunction from selling, transferring, alienating, and or creating any third-party interest and or changing the nature and character of the suit property till disposal of Can 1 of 2026. The appellant shall serve copies of Can 1 of 2026 as well as a copy of the memorandum of appeal on the respondents, indicating that the application shall next be listed in the monthly list of September 2026 when an affidavit of service to that effect shall be filed by the appellant.
Subject not to make any construction, my lord. Get making construction.
Change nature character.
Yes, my lord. Grateful, my lord. Grateful.
Item number 31.
Heard in part. I have to hear with Justice Bhattacharya. Is the matter is heard in part by a different bench, by a different division bench, let the same go out of the list, with a direction to be listed before the appropriate bench. এটা না যেদিন নেক্সট আমার জাস্টিস ভট্টাচার্যের সময় থাকবে এটা মনে করে দিয়ে দিতে হবে একটু আগে থেকে লিস্টে will in advance we'll publish in the list when we'll sit next so that all of you can have.
May I be permitted to mention before your lordship?
No, it will appear whenever we next sit. It will appear
By your lordship's order, automatically. I'm good. As your lordship.
Item number 32.
32, my lord, I beg to appeal. In the instant matter, my lord, the private respondent made a representation before the block land reforms officer seeking correction of record of rights in terms of the judgment and degree. That was not considered. My lord, they filed an original application before the learned tribunal. Learned tribunal passed an order directing to consider the representation in light of the judgment and degree passed by the court below. Well, the authority passed an order holding inter alia that the name of the respondents, the petitioner before your lordship, has been incorporated or mutated by virtue of a mutation proceeding, which is an appealable order. And since the order has not been passed by the appellate authority, they rejected the claim of the private respondent. Without challenging the appeal, the private respondent herein filed a contempt application before the learned tribunal, and learned tribunal allowed the contempt application, set aside the order of the Blockland Land Reforms Officer, and directed to consider to incorporate the name of the private respondents. Well, kindly turns to page 211, my lord. The parent order of the tribunal. My lord, may I be permitted to read?
Yes.
Learned counsel appearing for the applicant submit that the subject property was the joint property of the parties to the suit, for which a petition suit being number such and such was filed before the learned Munsif at Alipur, additional subjudge, and against that judgment no appeal was preferred. Thereafter, a title suit being number such and such was filed before the learned Munsif, third additional court at Alipur, and that judgment was affirmed by the appellate court being assistant district judge, 8th court at Alipur, in the title appeal number 468-1993. Second appeal was preferred before the Honorable High Court, Calcutta, being number 2 of 96, and it was dismissed by the Honorable High Court by order dated such and such. This was then, my lord, taking into account the background of this matter, BL and LRO Kolkata is directed to dispose of the representation in view of the judgment mentioned above, and taking into account the evidence available before him after giving opportunity of hearing to all interested parties, including the respondent, within a period of 6 months from the date of communication of the order. Not in compliance to that, the authority initiated a miscase, which appears at page 230. What? May I permitted to read out the only relevant portion?
Yes,
Page 260. The paragraph starts with hard the both sides at length. The submission is based on the averments made on way number such and such, consulted the relevant records. The main issues involved in the instant matter as submitted by the applicant side is that they want correction of record of rights in their favor in respect of LR plot number such and such on the basis of representation filed under the liberty given by the Honorable Tribunal. They perused all the documents from LR plot number 2018 of Mauja Paschim Borisha, jail number 119, district South 24 Parganas, was recorded in OPs of the instant case and others. The names of OPs has been mutated, their names which they get the property by inheritance. From the CR, no record is found against challenging the subsequent records in appropriate court of law, which was recorded in record of rights time to time. Further, no appeal in appropriate forum has been made, declaring subsequent order of mutation under section 50 of the same that executed by the revenue officer. Taking into consideration the recorded position of the LR record of rights of the suit plots, habits.
No, even if no appeal was preferred, there is a direction of the tribunal to take into consideration if a civil suit is culminates in a decree. That decree is binding on both of you, and it can be the record of rights should be corrected in terms of that. Which the order of the tribunal, previous direction of the tribunal, you have not challenged. Just because the previous recording was not challenged, this is a subsequent direction.
Whether the tribunal, while assuming the charge as a court of contempt, my lord, can sit on the judgment passed by the which is an
no question of sitting on judgment.
My lord, kindly consider the order.
Direction that attained finality, the previous direction which you placed first,
Yes.
that has attained finality. The direction on the authority, the BLLR, to correct the records of rights in terms of that whatever degree was passed.
In terms of the finding to consider and pass a reason order. My lord, not kindly.
Just because you did not challenge the previous recording, no, this is a subsequent cause of action. I mean, The tribunal directs subsequently that there is a decree, and according to in terms of the decree, you have to correct. So how can he say that no, the previous order was not challenged? This is a subsequent cause of action. You are in contempt. Rather, the BLLO is in contempt. Absolutely.
Whether that can be done in a contempt proceeding, my lord.
Contempt proceeding, nothing else is being done.
Yes,
His
my lord.
order is being sought to be implemented.
Yes, my lord, if your lordship kindly permit me to order.
Right. There should not be any ambiguity for correction of record order. He cites a peculiar reason the previous recording was not challenged in an appeal. So what? The subsequent cause of action has attained finality. No. Set aside. He saved the BLLO by doing this.
Whether the tribunal assume the charge of the appellate authority.
You were right in that sense, yes. Upon hearing Mr. Bhattacharya, we can revive this portion. We can set aside this, that set aside and BLLO. But any contumacious act can be nullified by the court also and tribunal. See, if an act is contumacious, contempt court can pass any other or further order in order to ensure that the order is complied with. So whatever subsequent steps have been taken in violation of that can be done.
In my respectful submission, they ought to have challenged the order passed by the authority pursuant to the
Why
direction.
should it be relegated to different forums? Tribunal has passed a specific direction. In the teeth of that, he is violating by passing another order.
If I correctly read, my lord, the tribunal has said in terms of the observation made herein before to consider the representation. If I have correctly read, my lord.
True, but in terms of the decree, we
cannot
lose sight of the other component of the order. Consider the representation, you cannot harp on that without harping on the other portion, that in terms of the partition should decree. If it has to be in terms of the decree, then a consideration has to lead to at least considering that. What was the shares decided? What is the title? That has to be reflected. But instead of that, he says only that it's a violation of the order of the tribunal.
Oh, that is an appellate order, my lord.
If we don't protect our tribunals, then what will remain? I mean, this is a gross violation. If a writ court had passed this order, this would be clear contempt. So the tribunal is now exercising power of 226, 227 virtually, without exercising so. But that's settled. No. We won't interfere. We'll say that in contempt, the tribunal has the power to nullify any contumacious act. MA was what?
MA, that is a contempt application.
The contempt application itself was disposed of.
Yes.
Should have been kept pending.
And yes, that was directed to correct the record orders in the mandatorily.
Yes, Mr. Bhattacharya, what do you say? Can the tribunal do this in contempt?
In my humble submission, to implement its own order, if your lordship kindly consider
yes, but
the order.
It comes to the same place. I mean, he again passes the same direction. It goes back to the same position. Why doesn't he keep the contempt pending?
What I find, that in the second order, the tribunal much more elaborate. While passing this order, give a specific direction to comply with the judgment.
The page 211?
Yes, my lord.
Which one?
211, my lord. Kindly consider, my lord, the second paragraph, my lord.
Yes.
Much more elaborate, my lord. So that, my lord, the concerned authority cannot depart, my lord, himself, my lord, from the judgment and decree which attains the finality.
No, he says, taking into account the background of this matter, BLRO is directed to dispose of the...
As I understand, my lord, one limb of submission of my learned friend is that there is a provision of appeal. The tribunal in contempt jurisdiction cannot assume the court of appellate authority and, my lord, pass this fresh direction. Now, my lord, the 10(3)(b), I think, my lord, is a reply, my lord, to that. Because, my lord, even if there is an alternative remedy, my lord, the tribunal can assume the jurisdiction.
10(3), the hardship.
Hardship.
On other day, my lord has held.
Land Reforms Act.
When, my lord, the tribunal find, my lord, that
10(3),
that is the hardship, my lord. On other day, my lord has held.
No, this is not hardship.
This is not hardship, my lord. On other day, my lord has, item 16, my lord has held.
Matlab relegating a person to at the initial stage.
No, we have to first clearly read the order which was under contempt, Mr. Bhattacharya.
Yes.
That we have to do, page 211.
Yes.
So, yes, the ground on which it was done probably is a mode of bypassing it. But whether specifically the civil court's decree was directed to be implemented, no.
No.
Directed to dispose of the representation in view of the judgment is
The judgment.
Judgment was not at all adverted to. This was not complied. He only says previous order was not challenged, so therefore I will not. It's a contempt. We'll revive the contempt application, maintain this other part of this order.
That's your lordship. But one thing I should be indicating, my lord, why I have before your lordship, the judgment appears at page 137. But the representation is something contrary to that, my lord. That is why, my lord, I have before your lordship.
No, that will be hard.
Yes, my lord.
That,
My lord,
the
that point,
PLLRO has to. Oh, acha. Now he has been directed outright to.
Yes, my lord, the representation says of 15 katas of land to be recorded in their name. Whether the judgment that was relied before the court, my lord, that appears at page 37 only in respect.
You have a point. The present impugned order probably goes beyond his original order.
Yes, my lord.
The original order was in view of the judgment that has to be and taking into consideration evidence.
Yes, my lord.
Contempt has been committed by saying that the previous order was not challenged. We agree with, but now is set aside. Up to that, it's fine. Directed to correct the record of rights in favor of the applicants may be a bit too much.
That is why, my lord.
Private respondent has been served.
No, this is since 227, my lord, without serving, my lord. May I serve and come back?
Not 226.
No, my lord. It was filed and that was withdrawn, my lord.
Serve a notice, then you have
My
to serve a notice. Very well. A prima facie arguable case has been made out in the writ petition in the present application as to whether the learned tribunal was justified in transgressing the boundaries of the original order under contempt, comma, while disposing of the contempt applications itself. Full by the original order, comma, the learned tribunal had directed the concerned BL and LRO to dispose of the representation of the private respondent herein in view of the judgment mentioned therein above, within bracket passed in civil suits, bracket closed, and taking into account the evidence available before him, comma, after giving opportunity of hearing to all interested parties, including the respondent therein, within a period of 6 months from the date of communication of the order. Next para, instead of doing so, comma, the concerned BL and LRO rejected the representation only on the ground that the earlier order recording the names of the private respondents and recording the name of the writ petitioners was not challenged in an appeal. Next para, however, comma, in view of the subsequent cause of action arising out of the direction of the tribunal to adhere to the judgment of the civil court, comma, we are prima facie of the opinion that a case of contempt was made out. However, comma, the limited question which falls for consideration before us is whether the tribunal exceeded its jurisdiction by directing the BL and LRO outright to correct the records of rights in favor of the applicants. In favor of the applicants are double inverted, comma, thereby transgressing from the original direction which mandated the BL and LRO to give an opportunity of hearing to all concerned and take into account the evidence available before him, comma, even apart from the judgments of the civil court. Next para. Accordingly, this application is required to be heard on the above questions. The appellant, the writ petitioner shall serve a copy of the application. How many private respondents?
One can.
Four. Serve copies of the application on the private
Three.
on the
Two,
private
three, and-
respondents, indicating that the matter shall next be listed in the month list of September 2026, when an affidavit of service in that regard shall be filed by the. Oh, there shall be stay of operation of the impugned order till September 30, 2026, or until further order, whichever is early. Much. এসছে হ্যাঁ যেটা রিলিজ করে ওই আর কি সুকান্ত দেখো আমাকে দেখো তোমরা দেখো
Supplementary concludes item number 1.
Lordship, for EKWMA, just received the brief, Your Lordship.
This is only for purpose of releasing. Mr. Sukant Chakraborty is appearing.
Yes, my lord. Lord Counsel, Mr. Chakraborty was appearing in the writ petition, my lord.
Since a relative of one of us within bracket Amar Puranamta is appearing for one of the parties, let the matter stand released on personal ground with liberty to the parties to seek an assignment before a different bench before the Honorable the Acting Chief Justice.
Lordship, one humble request, my lord. Can the order be uploaded today, my lord, so that?
Oh yes, all our orders are uploaded on the same day unless it's a very long order or the court officer goes home, which happens very rarely. Our officers generally don't go home before the upload.
Grateful.
We'll try to be as quick as possible.
My lord, same. 1, 2,
Same.
1, 2, and 3. All the matters.
Yes, my lord. আমি দুই আছি item number 1
আবার আলাদা করে রাখছেন কেন অল থ্রি সেম বললাম তো রেগুলার লিস্ট
এটা
আমরা তো
না
yes none appears for the parties, let the matter go out of the list. Next.
I am appearing for the petitioner in this.
Item number 34, my lord. If your lordship kindly take it up in the next week, my lord. Need some instruction, my lord.
May I indicate something, it can't be concluded today. So, my lord, may I indicate to your lordship the backgrounds of this case?
No, then we'll take it up next week. What's the use? We'll record it. And at
No, my lord, only one thing, my lord. May I be permitted, we are serving, my lord, one documents, supplementary affidavit filed by the unfortunately could not be annexed to the petition. We have found a supplementary affidavit. Let the supplementary affidavit be taken on record. It will be used at the time of hearing. I am serving copy.
Leave is granted to the writ petitioner to file supplementary affidavit, which is filed present kept on record, whose of a copy thereof is handed over.
Yes,
is handed over here and now to the learned advocates for the state. Whose of next pair on the prayer of the learned senior on the prayer of learned senior standing counsel, comma, let the matter stand adjourned till Monday till August 17, 2026.
Can it be on Tuesday, my lord?
Yes, why not? Then Tuesday?
Yes,
August 18, 2026.
My lord, I am also filing my affidavit of service. Let that be recorded.
Affidavit of service filed today be kept on record as well.
Yes.
Item number 35.
35, my lord, I beg to appear for the petitioner, my lord.
Yes.
But I am aggrieved by page 31, order of the learned tribunal, my lord. Page 51, I'm sorry, my lord. Now, order dated 27th October 2025.
Page 51.
51, my lord.
Appellate authority के party कौन है? এখান থেকে early hearing appellate authority के party করেনি বলি। इन्हें की hold कर लो। Agree. No, this is only for compliance of the appellate
Yes,
authority.
apparently it appears that it is a very simple order.
Yes.
But when this order was obtained by the applicant therein, by suppressing the fact that on the self-same ground and self-same prayer, another original application was pending at that material point of time. My lord, kindly see the way first, which was filed in this original application, page 34, it starts. The name of the applicant, page 35, Aruti Kumar. And only the state respondents have been made party, but we have not been made party. In the earlier original application, we have been made party. We were contesting the case, my lord. Now, kindly see, my lord, the prayer, page 39.
They have given a representation to correct the record of right.
Representation to correct the record of right.
Hmm.
My lord, in 2023, similar way was filed.
No, that we understand. I mean, the main representation is for correction of record of right, incorporating their name.
In
On the
compliance
strength of some previous order or something.
in strength of an order passed by the DLRO in the year 2001, which was passed in our absence and which is under challenge, my lord. We have challenged the same and that way is still pending. And a civil case was filed before the Honorable lower court, my lord, and injunction was there before passing that order.
So
That,
these ingredients ought to have been taken into consideration by giving a
yes, that has not been.
And in what happened to the previous way, that's still pending.
No, that was subsequently in the year 2026 withdrawn.
After this.
After this. Well, kindly see the previous way. The certified copy I have obtained, original certified copy. And these are the order copies, if you lot can. The order copies, my
Yes,
lord.
what do you say? They were not even made parties in this previous way was pending.
Yes.
You are for the private respondent. That's why you are.
Short pass one, my lord.
No. You have heard it, you are passing orders. We'll set this aside and we'll. Yes, Mr. Bhattacharya has to be heard. You are a neutral person here. State has nothing to say. So they had to be given a hearing. We'll set it aside, remand it, ask you to implement them as parties to this also, and have it done.
But the parties, but those were made in the earlier way.
Omitted here. We have checked that. That's why you are directing them.
Yes, omitted here.
Yes,
Only the state respondents have been made party and we have been deprived.
3 respondents, you are not there.
Yes.
You have seen that.
My lord, Sonam Bhattacharya.
No, we are setting aside. We are
Only, my lord,
this
only short
to
per
be reopened.
5
No,
minutes.
You
5
will
minutes.
implement them and they'll appear as parties and then get an order.
Only short pass one, my lord. Just my lord. Only short.
No, after you have heard it, you are asking for time. You should have done that at the inception. Sorry, no.
Only short possible. Only.
The present challenge has been preferred against an order whereby, in an apparently innocuous original application filed by the private respondents to implement a previous order of the DL and LRO, the tribunal directed the BL and LRO to correct the records of rights, incorporating the name of the private respondents in terms of the said order. So the next para, learned counsel for the writ petitioner submits that it was suppressed before the tribunal that at the juncture when the impugned order was passed, already a prior application for self-same relief was pending before the tribunal where the present writ petitioner was impleaded. However, during pendency of the previous original application, the second application was filed and the impugned order was passed behind the back of the writ petitioner. And subsequently, the earlier writ petition was withdrawn. Next para, learned counsel submits that several issues were to be pointed out to the tribunal, which necessitated the present writ petitioner to be impleaded and heard by the tribunal. For example, an appeal had been preferred against the earlier order which was directed to be implemented. Moreover, an injunction order was passed in respect of a civil suit where some of the parties were common. Full stop. Next para. In the absence of the writ petitioner, thus, the impugned order was vitiated. Full stop. Upon hearing learned counsel for the parties, we find substance in the contention of the writ petitioner, inasmuch as the tribunal overlooked the material suppression on the part of the private respondent to the effect that an earlier original application was pending, where the present writ petitioner was a party and had an opportunity of hearing. Full stop. Next para. Moreover, the factum of the pendency of a challenge and/or a subsisting order in a civil suit, as argued by the writ petitioner, was required to be brought to the notice of the tribunal before the impugned order was passed, outright directing the compliance of the said earlier order of the DL and LRO. Full stop. Next para. Accordingly, WPLRT 138 of 2026 is allowed on contest, thereby setting aside the impugned order dated October 27, 2025, passed by the third bench, West Bengal Land Reforms and Tenancy Tribunal in OA 2560 of 2025, LRTT, and remanding the matter to the tribunal with a direction on the private respondent to implead the present writ petitioner as a party to the যেখানে writ petitioner বলেছি সব plural হবে, writ petitioners as parties to the original application. Full stop. The learned tribunal, upon such impleadment and notice being served on the present writ petitioners, shall, upon giving an opportunity of hearing to both sides, proceed to decide OA 2560 of 2025, LRTT. Full stop. It is expected that such exercise shall be concluded as expeditiously as the business of the tribunal permits. No orders to cause urgency. Affidavit of service filed to be kept on record. You can take this back.
Yes.
You can use it before the tribunal.
Item number 33.
And the petitioner.
Yes.
My simple prayer before Lordship, only for direction upon that learned tribunal to dispose this matter for early hearing, because once Lordships, if all affidavit has been exchanged by the parties in the by contest in the before the learned tribunal, Lordships.
Well, I am appearing for the private respondent number 5 to 14. Well, in this matter, the original application is not maintainable. Kindly come to the, my lord.
We will not decide that from here.
Then, my lord, all affidavits are exchanged in between the parties. Kindly see this order, and my lord, let this matter be heard, because of the matter is fixed on the next, my lord.
Yes, you are directing that only.
Yes.
When is it fixed next?
Next after 10 month,
18 February 2027. After 10 months.
The innocuous prayer made in the writ petition is early disposal of OA 1909 of 2023 pending before the tribunal. Which of learned counsel for the writ petitioner submits that that long dates are being fixed by the tribunal despite the pleadings in the original application being completed.
Yes.
Full stop. We find from the impugned order dated April 24, 2026 that the matter has been next fixed for hearing on February 18, 2027. Full stop. Next para. In such view of the matter, WPLRT 139 of 2026 is disposed of by requesting the learned tribunal, requesting the first bench, West Bengal Land Reforms and Tenancy Tribunal, to dispose of OA 1909 of 2023 along with MA 1132 of 2023, LRTT, as expeditiously as possible, preferably within preferably by the end of December 2026, by preponing by shifting back the next date to an earlier date for such purpose. Full stop. No orders to cause urgency. The arekta line add kore the issue of maintainability raised by the private respondent as well as all other issues are kept open for being decided finally by the tribunal.
Affidavit service.
Affidavit service filed to be kept.
Item number 37.
37, my lord, I am for the state.
Yes. None appears for the writ petitioners, although the state is represented through counsel. Let the matter go out of the list. Yes. Private.
No, I have a state matter.
Those are the private respondents.
No, this is
Hmm.
seeking earlier disposal of the original application, or your lordship can refer the issue to the block land and reforms officer with the pleadings. All are complete, my lord. My lord, I made an application for mutation my name in 2017. A proceeding was initiated, hearing was accorded. My lord, thereafter nothing happened. In 2022, my lord, I made an original application before the tribunal. My lord, if your lordship kindly turns to page 32, wherein a innocuous prayer has been made to mutate my name upon disposal of the mutation case. Page 32, my lord.
There are parties there. The private respondents are parties. So
Yes,
to
ma'am.
dispose of the
Directing the
OA
authority,
itself will dispose of, will treat it to be disposed of and direct the BLLR.
BLRO to consider all pleadings because the affidavit has been exchanged in the
Giving
meantime.
opportunity of hearing to all concerned.
My lord.
The only thing I would like to point out is the prayer portion where that needs maybe correction. There's a site error.
What is there?
Correct, page 14 of this application. Rate in the nature of mandamus be not issued in for direct. That is the one error, my lord, and
Which page? Page 14.
page 14.
Page 14.
But also same error
You are granting prayer A.
and B also, my lord. State 2 also. 2 also same error.
Leave is on the prayer of learned counsel for the writ petitioner, leave is granted to the writ petitioner to rectify the prayer portion. Leave is granted to the learned advocate on record for the writ petitioner to rectify the prayer portion of the writ petition. Push up next para. The innocuous prayer made before us is early disposal of a representation pending before the BL and LRO in respect of mutation, in respect of the petitioner's request to mutate the petitioner's name in the concerned records of rights. Push up next para. It transpires that the original application from which the present writ petition arises was for the specific was for such specific prayer as well. Full stop. Next para. Since we are apprised that the that all concerned, including the petitioner and the private respondents, have already entered appearance before the BL and LRO, the ends of justice would be subserved if the OA is treated to be disposed of and the BLLRO is directed to dispose of the representation of the petitioner at the earliest. Full stop. Accordingly, WPLRT 141 of 2026 is disposed of by treating OA 4234 of 2022 within bracket LRTT, pending before the West Bengal Land Reforms and Tenancy Tribunal to be disposed of and directing which respondent BLLRO?
Respondent number 4.
Respondent number 4, that is the BL and Block Land and Land Reforms Officer Bushirhat Roman 2 to dispose of the representation of the writ petitioner for mutation of his name in the records of rights as expeditiously as possible in accordance with law, upon giving adequate opportunity of hearing to all concerned, including the writ petitioner and the private respondents, preferably within 4 months from the date of communication of this order to the respondent number 4. Full stop. For the purpose of compliance, the respondent number 4 and all others shall act on the server copy of this order without unnecessarily insisting upon prior production of a certified copy. No orders to cause such. Affidavit size file to be kept on record.
Not correction by tomorrow because the advocate on record, my lord, has left the court. My lord.
Acha, leave jeta dilam na correction by tomorrow.
Much. My lord, 39 may I get 1 day accommodation.
Not today.
Much.
You have fulfilled your quota. Yes. I get order record on the prayer of the petitioner, the matter is adjourned for that. So that we can catch you the next time. Yes. Yes. What is it?
Lord, I am
40.
appearing on behalf of the private
Private respondent. Who is for the state? So what is it?
No, my lord.
Will it be over in 5 minutes? Because you are appearing.
Only 5 minutes, sir.
In fact,
Actually, the property. Actually,
must be some intricate point involved.
Actually, this is a Borga land. I am the landlord. Borgada already died.
Their son now taking possession of the property, making constructions. Now they are trying to construct a mandir there from a dead, by bringing a dead body of a Hanuman.
Dead body of a Hanuman
Monkey. They are trying to usurp that entire property, grab the entire property. It is
The monkey is still there.
I'm showing the,
The monkey is still there on the site.
My lord?
Dead body of the monkey is
He's still there, like
Yes, yes, I'm showing.
and it become a news, my lord.
So what do you want now?
In
What is
the
detail?
meantime, the learned tribunal has fixed a date on 12th December, 12th October
What
2000.
an early hearing on the of that.
It should be hardly heard, and the injunction application is pending there. Let it be heard out.
What is the MA number of the injunction?
Injunction, this is
Separate MA has been filed. Or?
121.
1780.
1780.
And
That is substitution application.
And
12th October is the next.
My lord, may I?
12th October.
12th October is the
My
next.
lord, original application filed against the dead person, my lord.
You take that point before the tribunal.
And not only that, my lord, their complaint.
Have you taken that point in the tribunal? With the tribunal have
Yes,
taken
my
that
lord, they have filed substitution application, but before filing original application, their person died. So, my lord, substitution application is not.
Before filing of the substitution application, the person died.
No.
Will he die after
Before
the
filing of the original application.
I have already.
That prayer can be molded. That prayer can be molded.
And not
Prayer
only
can be
that, my
molded.
lord,
Addition of party.
the complaint lodged before the PLRO concern, my lord, the representation. Before filing representation, respondent number 13 died, my lord. How can they sign, my lord, in the
That is on the merits. The innocuous prayer in the writ petition is for early disposal of
Please see the death certificate, my lord.
of OA 121 of 2026 within bracket OA 2418 of 2025 bracket close and the connected MA number 1780 of 2025. For sub next parallel and counsel appearing for the private respondent submits that although an application for substitution of a deceased party has been filed, comma, the said person died prior to the filing of the original application. For sub moreover, comma, learned counsel for the private respondents also seeks to address on the merits of the maintainability of the original application. For sub next para, however, comma, the scope of the present petition is limited. As such, we decline from entering into the merits of the same, which are best kept open for decision before the tribunal. First up, we find from the order dated June 23, 2026 that the matter has been fixed next on October 12, 2026. First up, next para, accordingly, we dispose of WPLRT 143 of 2026 with a request to the third bench, West Bengal Land Reforms and Tenancy Tribunal, to positively take up the MA 1780 of 2025 and 121 of 2026 along with OA 2418 of 2025 on the said date and to dispose of the same.
My lord, in the meantime, I am bringing your lordship's attention page 73. They have already.
Don't pass any interim order. You can ask that before substitution.
If a mandir is erected, that will create a emotion in the
how can you do that?
In that case, a matter is required to be heard out.
Application itself is not maintainable.
Along with that, and thereafter, OA 2418 of 2026, 2025, and on the said date, and to dispose of the said applications, dispose of the same as expeditiously as possible, comma, preferably within 3 months thereafter.
Maintainability point be kept open.
All questions, including maintainability of the original application, are kept open for being decided by the tribunal. All questions, including maintenance. Yes. So, as a date person, how can you pass interim order now? Cannot pass.
No, my lord. Practically, they are not the Borgada. They are the son of.
Borgada or not, substitution application is pending. We can pass interim order.
RTL.